in Joseph Shine, am I clear in understanding that they were only looking at the penal provisions, IPC?
IPC.
And they did not have at least the ones that you are now proposing to put across, Air Force Act, Army Act, etc.
Yes.
Those provisions were not before the court?
No, they were not before the court. And I must point out at this stage itself that, my lords, earlier when 497 was still on the statute books, what was happening was that in similar cases, my lords, there is a provision, for instance, under the Army Act, Section 69, which talks of civil offences. Civil offences, in other words, offences which are punishable under the ordinary criminal law. Now, my lords, under such cases, we were taking it under 497 itself as a civil offence, under Section 69. Today, my lords, 497 is no longer on the statute book, and therefore, my lords, there are several other omnibus provisions which are available to us, which are flexible enough to accommodate, my lords, our action in such matters.
You are looking at the disciplinary aspect of the armed forces personnel.
It's also criminalization.
Also criminalization. Now, suppose what has been said. Now, because of that, am I correct in understanding what Mr. Parmeshwar and this group of people are saying? That somebody who gets cleared of the disciplinary action because of the criminal element being taken away is no more subject to the disciplinary action because of the judgment in Joseph's side?
Well, what they are broadly saying is that now that, and I'm not only...
You may go ahead.
Yes.
I'm just sort of... These
so, in a nutshell, what we find, because they are not the only ones, there are, my lords, a spate of cases which have arisen over a period of time, and this judgment is from 2018, where, my lords, we find routinely, first of all, my lords, there has been a huge rise in these cases which has come to the fore. Those are my instructions. Two, my lords, and we have given by way of illustration also, where what has happened is that as a defense, whenever there is they are charge sheeted, say under Section 45 or 63, which are now, according to us, very much available to us and flexible enough to take care of such offences. When they are being met with these charges, what they are saying is that Joseph Shine strikes down Section 497. It is no longer on the statute book, and now you cannot do indirectly what you cannot do directly. That is, in short, my lords, what I find routinely as a defense which has been taken in several of these matters. So 497 is gone and it's decriminalized, and therefore, even for the purposes of the armed forces, you cannot recriminalize or indirectly punish such conduct. Now, what I need to show to your lordships that insofar as the armed forces are concerned, one, I'll proceed in
your own way. I mean, don't
yes.
Let's not get...
So, very well. I will do that because I need to show the entire context, because what, my lord, 497 in a nutshell looked at was a very peculiarly structured provision. It was archaic, all of that. But it was looking at the offense of, my lord, quote unquote, adultery in the context of marriage, preserving marriage as a social institution. That was the object. And the object, as one of the learned judges also observes, was to control the sexuality of the wife in order to preserve the purity of the bloodline. That was, my lord, that archaic approach to controlling, my lords, the wife, and therefore, my lords, this was found to be manifestly arbitrary, etc., and it was struck down. But, my lords, we are on a very different note. We are not so much, my lords, on the institution of marriage per se, as much as, my lord, as the armed forces who are responsible for the security of the nation. We want to show your lordships how this can impact the operational efficiency and readiness of our armed forces, because this has not been seen at all in that context. And that is what we are concerned with, very simply, operational efficiency, which has a direct nexus with the security of the forces, the security of the nation. So, my lords, it may, because when I look at some of the defenses which have been raised, my lord, it appears to trivialize the issue. We are not here to impose some kind of Victorian morality on anybody. That is not that is not the purpose, and therefore, my lord, I need to articulate how we are going about this. So, my lords, that is the order of reference. May I also show the prayer now that we are, my lords, on it, and I want to just clarify one thing here. If your lordships may just look at the prayer in our application, page 27 of our application, if I may read. A. My lords have that. That persons subject to Army Act.
You're reading where?
I'm reading our application, my lords, the prayer.
Okay.
Page 27.
Yes, my lord. Your lordships have that.
Yes.
That person subject to Army Act, Navy Act and Air Force Act by virtue of Article 33 of the Constitution of India, being a distinct class, any promiscuous or adulterous acts by such persons should be allowed to be governed by the provisions of Section 45 or 63 of the Army Act, Sections 45 or 65 of the Air Force Act, and Sections 54(2) or 74 of the Navy Act, being special legislations and considering the requirements of discipline and proper discharge of their duty. Now, my lords, may I just clarify one thing at the very outset, that when we use the word adulterous in this prayer, my lords, what we mean, my lords, in a looser dictionary sense, we are using the word adulterous. We are not using it in the sense of 497, which had a very peculiar structure to it, which I will also point out. And when we use the word promiscuous, we mean, my lord, again, in the dictionary sense, licentious. Adulterous is, of course, my lords, extramarital affair should be enough to take care of the meaning of adulterous for our purposes. And, my lords, the expression requirements of discipline and proper discharge of their duty is also what falls from Article 33, which I will, my lords. My lords, before I take your lordships through Joseph Shine and explain that context, may I quickly, my lords, take your lordships at least illustratively through one of the acts, the Army Act. I'll take your lordships. The provisions in the others are similar. To show your lordships. My lords, please take the Army Act.
Is it your attempt to show that though for Section 497 is discriminatory towards women,
Yes.
this particular section, there is no such discrimination.
Absolutely. My lord, and
That is
insofar as
your
absolutely, my lord, insofar as we are concerned, there is absolutely, my lord, we are looking at it as gender neutral. And there are cases where we have gone.
that from your pleadings it is.
Yes, we have gone against women officers as well. And my lords, now it's a changed situation. We are going to have many more women in the armed forces. That's a reality. And both men and women will have to acclimatize themselves to this new reality. So that's also an important reason why this clarification is required. Lord, these are new developments. We have to acclimatize ourselves. But this is, we are, my lord, totally gender neutral. We'll show why 497 was struck down. Lord, may I first take your lordships to section 69, because this was earlier, my lords, the course of the course that was being followed was under 69 and civil offences, when 497 was still on the statute book.
Why you correlate your provisions to the Army Act or the Navy Act? It's 497.
Well,
unbecoming of an officer on moral grounds is in itself sufficient. You're not supposed to.
Absolutely.
Criminality is something different.
No, my lord, that is also, my lord, for unbecoming conduct, of course, you can be cashiered. You can be cashiered. For, my lords, acting contrary to or prejudicial to military, good order and military discipline, my lord, it can be, there is an imprisonment terms. So, my lord, I need to establish all that when I take your lordships through that as to why do we need to criminalize this kind of conduct? Because today the message that has gone down is that insofar as the armed forces are concerned, now that 497 is off the statute books, it is regarded as...
Ivan, you're the commanding
Yes.
mind. When we talk about 497, it is based on gender, man or woman. Nothing to do with your official status.
Correct, absolutely.
Nothing to do with the official status. Now, this court tests on the anvil of the requirement of the Constitution, reference to 497. It has nothing to do with your status, whether you're in army or in civil services or anywhere else.
Correct.
So, this is in the broader aspect.
Yes.
If you filter down, say sorry, it's persons who are serving in my organization are to be tested as per the provisions of this organization with respect to their conduct.
Right.
You will be right in saying, subject to what they say. But if you ask them, sorry, even if 497 has been struck down by this court, but as long as you are serving my institution, 497 will remain as a part
No,
of
we
that.
are not saying that. We are not saying that at all. We are saying
Yes, 33 there. 33 is a different.
we are not seeking to punish them, my lord, under section 497, the erstwhile provision. We cannot do that. That's off the statute book. All I'm showing your lordships is that it was a civil offence. It was on the statute book at the relevant time. We used to go under section 69 oftentimes in such cases. That's what I want to show your lordships. But today, there are other provisions on the statute book which are flexible enough to cover such situations of various different kinds of either unbecoming conduct or a conduct which is contrary to military order and discipline. Please see, my lord, 69 first.
69.
Yes, 69 first. Lord, I'm just trying to show your lordship the background that we went under 69 earlier. Now we are going under a different provision. Civil offences. Lord, civil...
The Army Act.
Army Act. Civil offences, your lordships might note, is defined under section 3 into brackets 2 of, my lords, the same act. Civil offence means an offence which is triable by a criminal court. So, for instance, my lord, 497 was a civil offence. Now, please see 69. Subject to the provisions of section 70, any person subject to this act who at any place in or beyond India commits any civil offence shall be deemed to be guilty of an offence against this act, and if charged therewith under this section, shall be liable to be tried by a court-martial, and on conviction be punishable as follows, that is to say, if the offence is one which would be punishable under any law in force in India with death or with transportation, he shall be liable to suffer any punishment other than whipping, so and so, so and so. In any other case, he shall be liable to suffer any punishment other than whipping assigned for the offence by the law in force in India, or imprisonment for a term which may extend to 7 years, or such less punishment as in this act mentioned. Now, my lords, this was, my lord, it says shall, which means that it was mandatory. But, my lords, be that as it may, now that section 497 is off the statute books, we now look at, my lords, for 45 and 63. These are two provisions. Please take 45, and I will be, my lords, at a later stage dwelling a little bit on what this really means and what is the purpose of section 45. Please see 45. Unbecoming conduct. Any officer, this applies, my lords, to officers, any officer, junior commissioned officer, or warrant officer who behaves in a manner unbecoming his position and the character expected of him shall, on conviction by court-martial, if he is an officer, be liable to be cashiered or to suffer such less punishment as in this act mentioned, and if he is a junior commissioned officer or a warrant officer, be liable to be dismissed or to suffer such less punishment as in this act mentioned. So 45 is one of the provisions under which we charge officers for what is regarded as unbecoming conduct or something, my lords, which is out of line with the character which is expected of him. My lord, this is primarily because he is an officer. He or she would be required to display a certain standard of conduct which is more rigorous and exacting than an ordinary person. And therefore, that was the purpose. But I shall dwell on this also further a little more, because I need to show that why do these provisions exist? Why are they, Lord, in the other side says that these are very vague provisions. It is required to be flexible, and I will point out why this flexibility is required. My lords, please see further 63. Violation of good order and discipline. Any person subject to this act who is guilty of any act or omission which, though not specified in this act, my lord, please note this, though which not specified in this act. So as of today, my lords, 497 is not specified in this act. Adultery or extramarital affair may not be specifically mentioned in this act, which, though not specified in this act, is prejudicial to good order and military discipline, shall, on conviction by court-martial, be liable to suffer imprisonment for a term which may extend to 7 years or such less punishment as in this act mentioned. Now, my lord, the other lesser punishments are, for example, you may lose your rank, you may be, my lords, you may lose your position, etc., etc. So there are many other lesser positions. But, my lords, what I want to emphasize over here is that it is any conduct which is prejudicial to good order and military discipline can be, my lords, punished. It is still a criminal offense. It has to be a criminal offense. If it is any act or omission, an act or omission not specified in this act which is prejudicial to good order and military discipline.
You see, one thing in mind.
Yes.
This court, after examining in totality, the provision has been held to be violative of Article 14 and 15.
Yes.
Now the question is, in your organization, you want to maintain some moral purity in the officers. Do it.
No, I would not put it like that, and I'll explain why. Yes, yes.
But once the provision has been struck down,
yes,
on the angle of the constitutional basis, then your subordinate legislation under the Army Act or some act would not carve out by say, sorry, this provision may be not be unconstitutional, but my subordinate legislation.
This is not subordinate legislation at all.
The act is
It is not subordinate.
Something which is unconstitutional. You can only say your saving clause now. This is nothing but saving clause to your organization.
No, my lord.
Then,
No. My lords, please see.
What you want to express
No,
to
my
us?
lords.
It is just a saving of
No,
your organization, not within the ambit of the verdict of this court holding to unconstitutional.
My lords, please see. I will have to show.
Under your Army Act, if you want to take action, take the action.
That is what we need. We are proposing to
Who
do.
is coming forward then?
My lord,
Somebody test.
that's the
for the court.
point. That
Let
is
it be tested.
no, my lord. That is the whole point. What has happened is this, please, and why we need the clarification from this court and from a 5-judge bench. And that is why the 3-judge bench, my lord, felt it necessary. It did not simply dispose of the matter and say, you decide in individual cases, let it be decided. Why? My lord, one, after 497 they are being struck down, there has been a spate of cases where all sorts of, my lord, things have come to light and are being, my lord, either they are in the process of being, my lord, those officers are being charge sheeted, or it is already in court martial, or it is before the AFT. It is pending, my lords, at various levels and at various stages. Some they may not have been charge sheeted at all. Now, my lords, the message that seems to have gone through, and I think, my lord, I need to elaborate a little bit on this, that now this conduct, that is an extramarital affair by either an officer or any personnel in the armed forces, is permissible conduct. It is now, because of Joseph Shine, which, my lord, it takes it much further than just gender parity. I need to point that out. In fact, some of them, my lord, can be misinterpreted. Now, the sense is, the message that has gone down, that this is permissible conduct. It has nothing to do with military discipline. And because it is permissible by no less than a constitutional bench of this court, therefore, we as the armed forces cannot punish you for such conduct. Now, my lords, what happens is, why do we have court-martial? Why do we have our independent criminal justice system in the armed forces? Because we need to act quickly. That's why, my lords, we have a choice of either, if there's a civil offense, we can go under the regular criminal justice system, but oftentimes we choose not to, because we need matters to be decided quickly. These are matters of discipline. So therefore, we go, my lords, the whole idea of a court-martial and having a separate system is to ensure that speedy, that certainty of outcome, immediate outcome. Now, what happens is this: when matters are pending all over the country, different units, this is happening. It is disturbing, my lord, the cohesion of units, and I need to dwell on this for some, my lord, I need to elaborate this. When all this is happening, my lord, look at the chaos that is taking place. Look at the uncertainty it is breeding. And it leaves us completely powerless to do anything, because every time, my lord, there is a charge sheet, there's a quashing application. Our officers are running from pillar to post to try and to defend it. Sometimes, my lord, in one or two cases, yes, we have succeeded in saying, but my lord, look at the rounds of litigation. There's a charge sheet, then you defend it. Then, my lords, the order is passed, then it goes back again into the court-martial. So, my lords, this is not a good thing for the armed forces, which the whole purpose is that a court-martial has to work quickly and efficiently. Now, if we are going to be paralyzed at this, that's why it requires a clarification.
You are testing not to your organization alone, you are testing in totality.
My lords, I will deal with all of
the
that.
man serving in some civil service.
Yes.
Is that man is not supposed to maintain that standards of morality?
No, he is.
You are expecting.
My lord, I am not. My lord, I have not opened my case on morality.
Exactly.
I have not opened my case yet on morality. So please, my lord, I would request your lordships to just allow me. Lord, what is unbecoming conduct? What is I have not opened my case on that. So please, my lord, allow me to do that, and I will make my case good. It is not so much about, my lord, morality, Victorian morality, and all of that. My case is purely and simply, my lords, on what is military readiness, operational efficiency, which impacts our security. We are only on that, my lords, and I will show why all this adds up and how it can have a serious impact. I have had a discussion with the officers on this. There have been real cases where this happened. Let me explain then, my lord, straight away before I go to.
Just one minute. Now that she's pressing the application.
Of course I am.
Yeah. Would your lordships first hear out our objection? Because there's something substantial to say on the objection. Because in the normal course, a matter of decision is referred on issues. Since there is no issues that are being formulated, we had certain substantive objections on the very maintainability of the application. Now that before she gets into the merits, I would want to appraise your lordships of what our objections on the maintainability are. And we're not shying away from an adjudication on merits, but I think this is a matter where your lordships must first understand what, at the outset, what our objections on the maintainability of the application itself is.
But we must also understand why they are coming up with that clarification petition.
She's explained that she's the.
No, I haven't opened.
Your objection, but what exactly is their case?
The prayer has been placed. The prayer has been placed. So I'm entirely in your lordship's hands. Your lordships want to hear our objections first on the maintainability, because this is a very unusual case where a clarification.
Three judges felt that five of us should give our attention to this problem. So already kind of it has entered this
because
court.
that was because they were seeking three wouldn't have anywhere clarified five. Simple. For the simple reason that they shouldn't have clarified what five judges.
Judges could have said that no, no clarification is needed. We often do it.
So my lordship, it's entirely up to your lordship to see whether your lordship hear the objections first or then get into the merits. We have serious
Aristotle somewhat has been crossed when the honorable three judges.
I'm sorry, my lord, that was ex parte. I'm sorry. With all due respect, that was ex parte. Three couldn't have clarified a fact. So, in that sense, three couldn't have clarified a fact.
They did not clarify. Their lordships did not clarify.
That's right.
Go through the order.
No, that's exactly what I'm. Three couldn't have clarified five. Therefore, they left it to a five.
The honorable judges also did not feel that this is not a matter which requires
I
clarification.
can only voice my concern. I'm making your lordship stand completely.
But taking note of the very object of the Army Act and the other acts. No, you should hear it. Hear them at least.
No, I'm saying that's a merit. I'm really saying the manner in which this matter is being heard by constitutional bench. Why it should a section which is not even under challenge is being brought in a preemptive strike, to use a military parlance.
Hearing them doesn't mean that automatically there will be a clarification. Question is whether it requires some clarification or not. So let them present their case. Why you are standing in the way of their presenting the matter?
I'm obliged. Lords, before I take my lords to this whole morality issue, which I do want to disabuse my lords of, but I just want to point out Article 33 so that it becomes clear that there is also, my lords, a lot of case law on Article 33, which at a later stage I will refer to. But, my lords, insofar as the armed forces are concerned, they are a class apart. They are a class apart. So even, my lords, on moral standards relating to other matters, there is a different set of standards which is expected of the armed forces. Please see.
Yes.
Well, of the Constitution, Article 3. Power of Parliament Power of Parliament to modify the rights conferred by this part in their application to forces, etc. Parliament may by law determine to what extent any of the rights conferred by this part shall, in their application to A, the members of the armed forces or the members of the forces charged with the maintenance of public order or persons employed in any bureau or other organization established by the state for purposes of intelligence or counterintelligence or person employed in or in connection with the telecommunication systems set up for the purpose of any force, bureau, or organization referred to in clauses A to C, be restricted or abrogated. My Lord, please note these words. So, my Lord's fundamental rights can be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of discipline among them. Now, this has been interpreted, my lords, several judgments. I will show that at a later stage. But let me, my lords, at least now elaborate on what Joseph Shine was about. What is that context? What are we concerned with? And is the compelling state object the same over here? Does it not require a clarification which will put to rest because it is impeding our ability to take disciplinary action within the armed forces? It impacts our security concerns. And therefore, my lord, to ensure proper discharge of duties. Now, my lords, so therefore, my lords, this was just to mention it at the outset that ultimately this is a class apart. The case law is very well settled. Armed forces, they form a class apart. And there is, my lord, fundamental rights can be restricted. My lord, they are restricted. Even the right to privacy is restricted for ordinary civilians. But apart from those restrictions, there are other restrictions which apply because of the nature of their duties, very simply.
Why can't you take us through the objects and reasons of the Army Act also? It has some relevance.
May I do that?
Please go through.
Certainly. I'm grateful.
Especially after 15th August 1947.
Yes, this came in 1950. Yes. Lords, may I read the SOR, the Army Act? Statement of objects and reasons. The need for a general revision of the three acts, namely the Indian Army Act 1911, the Indian Navy Discipline Act 1934, and the Indian Air Force Act 1932 has been felt for some time past. Some of the provisions of the existing acts were already coming out of date and insufficient for modern requirements, but after 15th August 1947, the need for revision became imperative for obvious reasons. It was therefore decided to revise all the three acts with a view to making them self-sufficient and complete codes in themselves. I'm so grateful to my Lord. The object was to make them as closely similar in form and arrangement of matter as the special requirements of each service might demand. Although the revision of the Army and the Air Force Acts has been completed, this has not been possible in the case of the Naval Act. The present naval
Only the first portion, that is the main thing.
Yes, my Lord, self-contained code, your Lordships are absolutely right. And in fact, when we discipline for good order and for military discipline, it is a form of self-regulation where only the armed forces can completely appreciate and understand what can lead to a trigger which can be a breach of military discipline, which can impact security. And therefore, it is a self-contained code. This is self-regulation at a certain level. My Lords. Now, my Lords, just coming to just a preface which I want to make to Joseph Shine, what Joseph Shine dealt with, and then, my Lords, I will explain the morality and the standards aspect insofar as, my Lord, the armed forces are concerned. My Lord, may I preface my arguments insofar as Joseph Shine is concerned by saying two things broadly. One is that, my Lords, the court was concerned with a peculiarly worded provision where the court was really looking at it in the context of the institution of marriage. The important thing that I want to say here, my Lords, is that the court was not concerned. It was not concerned with the impact of an extramarital relationship in the context of a workplace or a work culture. And certainly not in the context of a work culture as unique as the armed forces. So my Lord, Joseph Shine was in the context of the institution of marriage and not in the context of a work culture. Two, my Lords, the compelling state interest, which eventually led to the striking down of 497, was that it was not only concerned with preserving marriage and therefore it could not be criminalized. It was recognized as a wrong. It was recognized as deception, etc., as a ground for divorce. That all that the court preserved. But what it said was that ultimately this is patriarchal, it is out of sync with the times. And the idea, the object, the compelling state interest was not only preservation of the institution of marriage, but to preserve and to control the sexuality of a wife so as to preserve the purity of the bloodline. That was as, my Lord, archaic as the provision was. It was in the my Lord, 1800, and that's what Justice Chandrachud actually observes in that. The idea was to preserve the purity of the bloodline and therefore control the wife. So, my Lords, this is not the prism that we are concerned with. Our compelling state interest is going to be military discipline. Of course, I will show how it can both really and potentially impact military discipline. That I will show. But, my Lords, that is what I want to just preface Joseph Shine by saying. And ultimately, my Lords, what the court found, that this is 497 is such an illogically framed provision because the wife of my Lord, the adultering man, she cannot be an aggrieved person. She could not, the wife of the man who was involved in the adulterous relationship could not be an aggrieved person. My lord, the wife who was actually involved in the adulterous relationship, she was not even an abettor. She could not be an abettor either. It was the man, the so-called adulterous man, who was the perpetrator. He was the seducer, etc., etc. And it was only her husband who could complain, because he was the aggrieved person, because the wife was his property, his chattel, etc. And he had the right to control her. So, my lord, we were concerned there with a very peculiarly structured provision, very utterly patriarchal. But, my lords, apart from this, it being completely gender, in fact, anathema to gender equality, there was another aspect which is also tied up with this, that the court recognized that there is a fundamental right to privacy that both men and women enjoy. And, my lords, I will be pointing out that there was perhaps a discordant note at a certain level between two opinions, which, my lord, I certainly see. And which is that, my lord, one opinion seems to suggest that there is privacy both within marriage, the right to sexual choices within marriage, as well as outside of that relationship with a third party as well. That is what one of the judgments certainly seems to suggest. So, my lords, whether this will also be used, because that is also being used as this is our right to privacy, even to have an extramarital affair. Whereas another of the opinion, Justice Malhotra's opinion, my lords, says that no, you do not enjoy Article 21 protection for the purposes of an adulterous relationship. So, my lord, there is a little bit of a discord there. But eventually, my lord, there are observations which seem to suggest that in no situation other than those which have been identified can any such conduct within or outside of marriage be criminalized. So what is therefore a criminal offense? What do you need to show in order to criminalize something? There has to be a societal interest, etc. And the court seems to find that paragraph 58, which I'll show your lordship, that only in these situations can you criminalize, which includes, my lord, for instance, domestic violence or dowry, etc. But therefore, the question arises then, my lord, the armed forces, that was never an issue. In fact, no workspace or no fallout of an extramarital relationship in any workplace, whether a civilian workplace or the military workplace, has been taken into account at all. So, my lord, even in ordinary, my lord, corporate organizations today or in a university today, you have to make a disclosure, for instance, if the professor is in a relationship with his student, or, my lords, in firms also. You have to make, even if it's not an extramarital affair, is that not nobody questions that? Why? Because it can have an impact on the relationship. If you are a professor in an extramarital relationship or a relationship with your student, for example, there can be bias you show. So therefore, disclosures are essential in those, in a work, in any other work environment as well. But when we are talking of the armed forces, it's a very different and unique ecosystem. So, my lord, before I get into Joseph Shine again, let me just identify those areas where this can have an impact on good order and military discipline, how this can be, and what is unbecoming conduct. These two provisions.
Is there any definition of unbecoming?
Well, there are some judgments. We have some literature on this. But, my lords, a lot of the time it has been described, it's vague, it's rather omnibus. But there is a reason why it is so. Because in matters of military discipline, you cannot always anticipate what is going to happen. So the judgments also recognize that you have to have sufficient flexibility to be able to deal with the situation that you have to deal with. And what is unbecoming conduct ultimately, and why do we lay so much emphasis on unbecoming conduct? I must explain that.
Because this unbecoming conduct in civil life in view of Joseph Shine has become a becoming conduct.
My lord, I would not say that, but I would say that it cannot be criminalized.
It's okay. It's
Right. So my lord,
criminally becoming conduct.
it is, my lord, it's permissible in terms of it's not
Whether
criminally.
in the armed forces, we can import
Yes, I'll address that.
same becoming conduct and transform it into unbecoming.
Right. So
While you are looking this judgment, Shine's judgment, one particular portion you will have to give some advice. See, it is this. Viewed from the said scenario, the provision really creates a dent on the individual independent identity of a woman when the emphasis is laid on the connivance or the consent of the husband.
yes.
This tantamount to subordination of a woman where the Constitution confers equal status. So it is a husband decides.
Correct.
Just
Correct. My lord, I'm going to, in detail at a later stage, I'm going to go into Joseph Shine. But, my lords, I'll just. My lords, this concept of unbecoming conduct and why one, as an officer, one must behave in a manner which is consistent with your position. Ultimately, it cannot be, my lord, the expression is character.
Had this been specified as an unbecoming conduct in your code, maybe one course you would have been in better footing.
My lord, let me say this.
Because you are, see, something in general law has been found to be
not becoming, my lord. It is not. It is still not. My lord,
not a criminal conduct.
Yes, it is not criminal. So, my lord, may I say this?
So, but the civil
So let me say this.
element of its kind of
No, what happens, my lords, in the army? It's a peculiar and a unique ecosystem, and why that?
we understand.
Yes.
We are
No.
trying
So
to-
I need to elaborate
we are
why.
trying to look at the code.
Right.
Whether code permits you independent of Joseph Shine judgment.
Yes.
That's what we are looking at.
Right. My lord, I'll address your lordship. My lord, but please bear in mind that merely because Joseph Shine decriminalizes adultery as understood in 497.
Possibly still it's a ground of divorce under.
It's still so, my lord, if it is a ground for divorce and it remains so, it is recognized as a wrong. It is a
necessarily it's recognized
as a breach of
for
trust.
dissolving the.
It can be, my lords, it would be, certainly I would say that it is still, it is infidelity. It may not be criminalized for ordinary civilians.
It's not a civil wrong also. It's a ground of divorce.
My lord, it's a ground for divorce. It's an act of infidelity.
It's not a tort.
It could be an act of breach of trust.
It is not a tort as yet.
My lord, it has to be tested. I have not applied my mind to that aspect, frankly. But
it has to be a specific.
It is certainly not becoming conduct for anybody.
As regarding tortious part, there is only one reference, in the Joseph Shine judgment, referring to a South African judgment which said even compensation one is not entitled to. But in Joseph Shine, it was not gone into further at all.
We may not be in tandem with the value system of South Asian, South African jurisprudence, but of course we have to tune it with the global.
Correct, absolutely. That exercise has been done in Joseph Shine. The global scenario was well gone into, but the question as to whether it is a tort, it will amount whether infidelity will amount to tort.
We are not entering into that. We pose this question only to understand whether it is a civil wrong.
Yes. That was not
under statute.
It was the infidelity was found to be a moral wrong in Joseph Shine, but the compensation aspect was not decided in Joseph Shine. That's what I would say. There is a reference to certain other jurisdictions wanted to indicate that, but that was not pinpointed.
Yes.
What is passing through our mind so that you can modulate your.
Right.
Yes.
My lord, therefore, my lord, I started by saying that we need to, my lord, take this prism off of Joseph Shine in the sense of, because it was not considering neither any workplace or work culture, the fallout of an extramarital relationship in the context of a workplace. We are talking of what, my lord? We are talking of military discipline. So therefore, whether it is becoming or unbecoming in the civilian context, in a home, etc., is no concern as far as this is concerned. We are concerned with this. My lord, please see how it can have an impact. There are two provisions I showed. One is 45, which talks of unbecoming conduct and of acting in a manner which is maybe inconsistent with the character which is expected of an officer. And the second is, my lord, prejudicial to, my lord, military discipline and good order.
That is 63.
Yes, 63 and 45. There are two separate provisions. And there are similar provisions in the other acts as well. Now, my lords, please yes. Yes.
Different way of looking at it. Let's come to 497 of the Indian Penal Code.
Yes. Whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man without the consent or connivance of that man, such sexual intercourse not amounting to the offence of rape.
That's right. Now, you take a situation where a person in the army officers, he has an extramarital affair with wife of somebody, and the husband of that lady, she has no objection. He has no objection. He consents. He connives. It remains, however, an extramarital agreement. So, will it be an offence under Section 497?
But under 497, it may not, because it has.
It will not be.
Yes, but under my law, yes.
Under your law, will it not be absolutely a reprehensible conduct?
Absolutely. Yes. Because, very simply, suppose he is an officer.
Yeah.
My lord, there are people under his command.
That's it.
Now, my lords, in the army, the most important factor, which I am emphasizing here,
Character.
the cohesiveness of the unit, the bonhomie and the fraternity of the unit has to be kept together.
Yeah.
Now, my lords, these are persons who under your command have to be willing to do or die. Yes. Correct. So, my lords, if they find that here is a man who is having an affair with somebody who was in any kind of inappropriate relationship, unless you can inspire that awe and that respect in those who are under your command, they may not obey you. It can therefore lead to.
Notice that this man is having an extramarital.
Yes.
The husband is also, he's not concerned.
Correct.
He's consenting. So it's not an offence under 497. So
Correct.
So you will still be able to proceed under your law.
Correct. But, my lords, there may be cases where it would have been an offence under 497, but I can still proceed under my law. Because, my lord, it's a simple thing that if, my lord, there is a certain, my lord, a cohesiveness which is attached to a unit in the armed forces. And, my lords, here is a situation where people have to be able to do or die at your command. It requires a very different type of psyche and a mindset to get people to ultimately, my lord, conform and to follow your commands at a flash. Now, if you do not command the requisite, and that's where the expression officer and a gentleman, today we will say officer and a gentlewoman as well. But my lord, that is how.
No. Don't interrupt now. Let him. Yes.
So, my lord, this is the concept of an officer and a gentleman. What is that character which is expected of you? It has to be more rigorous, more exacting than any ordinary person. Even a person serving under you. You have to set that example. If you think they are ready to lose, they have to be ready to lose life and limb at your command. So therefore, my lords, in that context, the command structure, which is the most sensitive thing in an army organization, the command structure gets disrupted, disturbed. If you see that your commander is behaving in an inappropriate manner without a care in the world, whether he's intoxicated, he's in an inappropriate relationship, whatever the unbecoming conduct is, it's not conduct which is expected of such a person. It is likely to lead to not just insubordination and a breach of military discipline, but it can actually imperil our security concerns if they refuse to act upon his orders. That is point number one. Secondly, my lords, it can also have an impact this way. Unbecoming conduct. Please see, suppose there is a person in a commanding position and with his subordinate, he is in an extramarital affair or some kind of affair, even if it is not extramarital, my lord. Please see this. If your unit members who are supposed to function as one body, one group, one complete cohesion and adherence, if they feel that you are going to favor this person or there is some favoritism being shown because of a relationship you are in, again, my lord, this can trigger off, my lord, nothing less than a mutiny. It has happened. It can trigger off something very serious. And here, my lords, we are in situations where you may be serving out there, you may be living together in barracks, you may be serving in some very arduous situation, you may be out in a submarine for months on end. If you have a situation and your people in your unit are not willing to obey you because you have acted in a manner which is unbecoming, then, my lords, it's a very serious security concern. Very serious. So, my lords, I would not overemphasize the morality bit.
You omitted to say one thing.
I'm sorry.
You said that they are to work as a unit.
Yes.
With a single mind.
Yes, absolutely. Absolutely. And if I may just elaborate.
That is the success of.
Absolutely. In fact, my lord, what the literature on this, and it's very interesting, I also learned something from it, which is, my lord, in a unit in the armed forces, there is a certain surrender of your individual instincts, of your individual idiosyncrasies, of your individual affections, because what is the unit demanding of you? It is demanding, my lord, a collective identity, a complete coordination, what, my lord, Justice Chandrachud in one of the judgments refers to as esprit de corps. That is the spirit. It's a living spirit of the unit. You cannot, in fact, my lord, in fact, symbolic of this is the uniform which you put on, which is meant to make you not just that you stand out in a crowd, but that you are one like anybody else. You're members of a unit. You're supposed to act at somebody's command in a flash. You do not question those orders. Everybody else, my lord, in civilian society, we question everything. We show our individual identities. We wear our diversity perhaps on our sleeve, but you cannot do that in an armed force. You have to act when you are told to act. You have to be willing to give up your life if you are told to do that, and to kill, of course. So, my lords, what is it, that mindset that is able to, you have to have enormous respect and awe for the officer commanding you, and you yourself as a part of the unit, you have to act in complete coordination, complete synchronization. So one symbol of that, my lords, is the uniform. Another symbol of it is, my lord, for instance, on Republic Day only last week, we saw how the regiments, my lord, when they march together, that is also symbolic. Why is it that every limb, every cell of the body almost is, my lord, acting in complete synchronization? What is that meant to symbolize? It's not just a routine exercise. It's meant to not create that spirit.
We respect. But at the same time, you have to test on the anvil of what has been said by this court. See, we respect our army here, the way they are dealing with, they are giving security to all of us. Nothing wrong in it. But we have to examine in the anvil of the mandate now given by the court here. And now you see Article 33 once again. You see Article 33, but this is an amendment made somewhere in 1984.
Well, the amendment was made, and that is armed forces, it always applies, but the other...
Now, what we are requesting you, if you see, the Parliament may by law determine to what extent any of the rights conferred by this part, that is Part B, shall in their application to leave it, be restricted or abrogated. Now show us, under Article 33, which are the rights available which can be either restricted or abrogated?
Lord, all rights can be restricted or abrogated. Yes, my lords. My lord, please see, what is the right here that a person can... My lord, please let me just, for instance, my lord, in the case of an extramarital affair, what is the right that an ordinary civilian can claim? He can say, this is my right to privacy. You must not interfere in it. It is my right to, my lord, sexual privacy, as the court has also upheld in Joseph Schein. So therefore, it is maybe my Article 21 right. It may be my right of expression, 19(1)(a), whatever. My lords, even in the case of a civilian, ordinary civilian, if there are security interests which are at stake, for instance, in any given case, you can't claim your 21. It can be curtailed so long as there is a law, there is a legitimate state interest, and so long as the procedure is reasonable, you can curtail it. Of course, you can curtail it. Therefore, my lords, in the case of the armed forces, members of the armed forces, not only are the regular other restrictions which are applicable to civilians and to the other restrictions to the fundamental rights, those restrictions can be invoked. In addition, we have the protection of Article 33, where, my lords, judgment after judgment holds that this is a class apart. Look at what these people have signed up for. Look at the level of sacrifice we are willing to give up our lives. Somebody commands you, you go and either you shoot or you get killed yourself. What is ultimately, my lord, this is a much higher standard and rigor. We cannot, my lord, our civilians cannot even begin to appreciate what is the level of, my lord, what is the mindset of those people that has to be. If my lord, it can be understood by anybody that Joseph Schein means that you can be, my lord, having any kind of affair or relationship. My lord, look at under the Army Act, for example, a sentry who is sleeping on his post. What is the punishment? Up to 14 years imprisonment. If he is intoxicated on his post, up to 14 years imprisonment. My lord, for a civilian, if you are found to be sleeping on your job, you will be let off with a reprimand. You may say, one may think that, oh my God, 14 years or whatever imprisonment, but it is therefore punishable with a jail term. Why? It's a class apart. We cannot reason with what is necessary for military discipline because we cannot even begin to, my lord, appreciate that level of rigor which is required. And, my lord, one of the articles, and that is an American article which says, a person who cannot have that much control over his individual instincts, what will he do in a combat situation? What will he do when the time of reckoning comes? It's not just, it is a very important thing that I have to set an example if I am a commander for the rest of my unit. But other than that, I also have to have that level of mental strength, of control over my instincts, that I behave in a manner which is behoving of an officer or behoving of somebody who is serving in the armed forces. Now, there are many ways, my lord, in which this kind of conduct can imperil security interests. One is simply, as I pointed out, there can be complete insubordination. You can have a mutiny if somebody feels that somebody else is being favored. I will not act because this man does not deserve my respect. It has happened in several situations. One. Two, my lords, ultimately, my lord, an extramarital affair, it may be an act of stealth, it may be a breach of trust, it may be, my lord, it's an act of infidelity at the end of the day. Now, if you are embroiled in that situation, obviously your alertness, your preparedness, your readiness, which you have to have, your reflexes are questionable. You're not going to be in that position to act. And, extramarital affair is only one type of conduct which can amount to a breach or be prejudicial to military discipline. There are a whole lot of other things which sometimes, my lord, is not an exhaustive thing. So, my lord, that is one aspect. The third, as I've already pointed out, is the breach of the command structure, which is, my lord, very dangerous, very, very dangerous. The fourth, my lords, and here, my lord, perhaps some morality element comes out. Where, my lords, here are people who, like no other, have to leave their families and serve on a front. It may be a peace station, it may be a combat station, whatever it is. For the longest time, they leave their families. In other jobs, perhaps one may say that also people have to go. But do they go with that uncertainty? Am I going to come back? Am I going to see my family again? In such a situation, my lords, if in that my lord, situation, a member of the family or a spouse is in a relationship with somebody else, whether civilian, officer, whatever. My lord, can as an employer in the armed forces, my lords, can the Union of India turn back and say that I will turn a blind eye to this? It doesn't matter to me whether your family is in harmony or there is integrity in your family. Your integrity as a family, your well-being, your harmony matters to us as employers. Otherwise, we will not have people who will be willing to give up their lives and go there on the front. So therefore, my lords, we cannot turn a blind eye as employers. We have to have public confidence. They have to have public confidence in us to raise their morale so that they can fight for the rest of us. So, my lords, these are the various factors.
So, what you are trying to say is that first and foremost, Constitution itself under Article 33 recognizes a different or a higher standard of benchmark for discipline.
Yes.
And the discipline that you expect in the domestic sphere, so far as the armed forces personnel are concerned, it has to be replicated in a combat situation also. So therefore, there cannot be any compromise on the standard and discipline and the benchmark that you set higher, which is constitutionally recognized under Article 33.
Yes. Plus, my lord, as I have explained, it can have either a real or a potential impact on my ability to perform my duty. So I don't even have to, my lord, as a employer, I do not even have to wait for instance, if say a commander, an officer is having an affair over there, I cannot wait to see whether that actually impacts in a combat situation. Will they obey him? Will they not obey him? We don't wait to see that.
Cannot be waited.
We cannot afford to. If he is behaving in a certain way, if he is conducting, we have to act immediately. We have to, because we cannot risk that insubordination or that unrest in the unit.
It is not a domestic affair.
It's not. Because this is the fallout. As I said, my lord, even in so many civilian situations, you have to disclose when you are in a relationship in an ordinary work environment. My lord, in the army, we are talking about something so different. So therefore, my lords, this stands on a very, very different footing. And when even Article 33 says, my lords, it says restricted or abrogated so as to ensure the proper discharge of their duties. So therefore, we can abrogate it at the very inception. We can act. When you are in an affair, if you are found out to be in an affair or whatever it is, you are intoxicated on duty, etc. We don't wait to see whether your intoxication is going to...
What you are calling upon us to do it?
No.
What you are calling upon us?
I'm only calling upon your lordships to simply clarify that I am not, because of Joseph Shine, I am not precluded from acting under 63 and 45 and whatever other provisions under Navy Act, similar provisions under the Air Force Act. I am fully within my rights to act.
Read section 497, it says, Cardinal including this section. Correct? Now, so you see, I go judgment in 16 Kerala Law Journal and read on divorce. Contemplates a certain measure of penetration of the male organ, as it were. You could have a person, army man, being in a relationship where you don't go the whole hog, as it were, and you stop short, but you are engaged in conduct which the army considers as important.
It's good enough for us to act.
We just wanted to.
Yes,
there
yes.
are areas, gray areas,
Not because.
where this judgment will not stand in the way.
No,
You don't
yes,
have to.
yes, because ultimately, my lord, what are we concerned
Yes,
with?
yes.
We are not concerned with the purity of the bloodline. That would have some effect.
Concerned with that.
We are concerned with military good order and discipline.
That's right. You don't have to prove what you're trying to
Yes.
say. Is that you don't have to go a whole.
No, none of that.
Supposing you indulge in, say, oral, what is called oral sex, or whether you indulge in what is called unnatural, with that. Because
So that may sodomy, etc. That may fall within disgraceful conduct.
disgraceful conduct that's covered by that. So you have to be very clear what we are actually saying.
No, we are concerned in this application.
Actual sexual intercourse will be
No.
covered by 497.
Not an
The way
extra.
497 doesn't stand the way.
Yes.
See, if it is not covered by 497, the ingredients of 497, you don't come under the shadow of that judgment at all.
No, but what if?
All the
What
ingredients
if?
are satisfied?
What if all the ingredients in a given
That's-
case are
we have to
satisfied?
consider that position only.
My lord, I am, in my respectful submission, it will still be punishable because it falls under,
A different offense, you're saying.
it is unbecoming conduct if it's an officer. And second, my lords, insofar as 63 is concerned, it may be prejudicial to military good order and discipline. So therefore, my lords, it comes, these are umbrella, and we cannot exhaustively define what is unbecoming conduct. The judgments also say that ultimately we also as the army, we have to have that kind of flexibility to decide what comes under that kind of conduct, which can have an impact on, which can have an impact. I don't have to wait for the impact on military discipline.
But what has been declared to be unconstitutional for the common man, if you make just as a generality and
Yes.
from a special class, can you actually resurrect it and make it a distinct offense under the section dealing with general offenses?
Right. So, my lord, that is the reason we are here. We are not here, my lords. Ultimately, what we want your lordships to appreciate is that when 497 was being considered, your lordships were not concerned with the fallout on any work culture or workplace, let alone the army. Your lordships were not concerned with that context at all. Your lordships were concerned with marriage per se. So our compelling state interest is different. The sections we are invoking is different. They show that the object is different. Military discipline. Operational effectiveness is what we are concerned with. As an army, we have to act. And anything which imperils that, whether it is your drunkenness, whether it is your extramarital affair, whatever it is.
Disgraceful
As long as
conduct.
you don't,
Disgraceful conduct, you mean.
as long as you don't actually rely on 497.
No, we can't. The 497 is
So if you don't rely on 497 and it falls within the contours of a separate distinct offense under the Army Act, Navy Act, whatever. I mean, okay.
not distinct.
Nobody stops you
Why?
from doing it.
So 63, that's what I wanted to show your
If you
lordships.
can bring it under that. This question has fallen in on many occasions under Article 22. It is double jeopardy.
Yes,
There are case law.
yes.
Separate offense. What? Because there is subtle distinction. Because you might think that they're overlapping.
Well, 63
They can
says,
consider distinct offences and a large body of case law
Right.
under 22.
right.
Double jeopardy. There are section 300 of the CRPC, which
No, it would be double jeopardy if the object
Therefore,
is the
what
same.
we are trying to tell
Yes,
you.
it's not.
If you have a distinct offense, which perhaps borrows part of what is contained in 497, it would not make it the same offense.
No, we are charge sheeting them under my lord 45 and 63, where we say that this is conduct. You are having an extramarital relationship.
Well,
And because my lord 63, please note, it talks of a person who is guilty of any act or omission which though not specified in this act. It's not specified in this act. So I do not need to have a specific a provision which says that X Act comes under 63. I can, my lords, any act, including an extramarital affair, any communication, for example, an obscene communication, for instance, my lord, if it is not otherwise.
All of that is there. I mean, you are free to do that.
That is, my lord, what we
Absolutely,
want.
you are free to do that.
My lords must say that because, my lord, please see, it will put an end to this uncertainty and confusion.
Part of the army discipline.
That is what we want your lordships to say. That is, my lord, there's actually a lot of literature on this. There are judgments on this. Either I can put it in the form of written submission, or I had actually intended to take your lordships through Joseph Shine.
Which part you want us to?
No, actually, there was a lot. Yes.
Yes.
A lot of international literature also on this whole idea of unit cohesiveness.
Did you not, because you are Government of India was a respondent, because you are the author of the law, and did you not bring this aspect to the notice of the court? That is angle relating to the Army Act, and is there anything which deals with it? The court?
Not at all. And also, my lord, suddenly people seem to believe that this is some kind of carte blanche or license. That's the problem. And they start raising 497, you're trying to do something indirectly what you can't do directly. My lords, one of the problematic paragraphs is 58. At page 101. Treating adultery an offense, we are disposed to think it would tantamount to the state entering into a real private realm. Under the existing provision, the husband is treated as an aggrieved person and the wife is ignored as a victim. Presently, the provision is reflective of a tripartite labyrinth. A situation may be conceived where equality of status and the right to file a case may be conferred on the wife. In either situation, the whole scenario is extremely private. It stands in contradistinction to the demand for dowry, domestic violence, sending someone to jail for non-grant of maintenance, or filing a complaint for second marriage. My lord, the court seems to come to the conclusion that only such acts can be criminalized. Adultery stands on a different footing from the aforesaid offences. We are absolutely conscious that Parliament has the lawmaking power. We make it very clear that we are not making law or legislating, but only stating that a particular act, i.e. adultery, does not fit into the concept of a crime. We may repeat at the cost of repetition that if it is treated as a crime, there would be immense intrusion into the extreme privacy of the matrimonial sphere. It is better to be left as a ground for divorce for any other purpose, as Parliament has perceived or may at any time perceive to treat it as a criminal offence will offend the two facets of Article 21 of the Constitution, namely dignity of husband and wife, as the case may be, and the privacy attached to a relationship between the two. So, my lords, the suggestion in this paragraph seems to be that other than, for instance, bigamy or for non-grant of maintenance or for domestic violence, if you criminalize, then it is violative of Article 21. To which, my lords, my answer is, one, the court was not considering, it was farthest from the court's mind in our respectful submission, challenges that are there in the armed forces, one. And secondly, in any case, my lord, 21 can be restricted, even otherwise for civilians. 21 can be restricted, even insofar as, my lords, 45 and 63 clearly restricted. Then, my lords, you see further. Lord, can I take your lordships more in a little more detail through Joseph Shine? Because
which part you want us to?
Yes, so my lords, I would urge your lordships to look at some parts of Justice Chandrachud's opinion.
Which part of the judgment really stands in the way of your proceeding under the various provisions of the Army Act?
My lord, One I have shown your lordships is 58.
58.
The second, my lords, for instance, is, my lords, if your lordships just sees paragraph 135 onwards.
155.
135 onwards. So that's Justice Chandrachud's opinion. Please see 135 at page 135. In 19th century Britain, married women were considered to be chattel of their husbands in law, and female adultery was subject to ostracism far worse than male adultery because of the problem it could cause for property inheritance through illegitimate children. Consequently, many societies viewed chastity together with related virtues such as modesty as more central components of a woman's honor and reputation than of a man's. The object of adultery laws was not to protect the bodily integrity of a woman, but to allow her husband to exercise control over her sexuality in order to ensure the purity of his own bloodline. The killing of a man engaged in an adulterous act with one's wife was considered to be manslaughter and not murder. In R versus Morgridge, Judge Holt felt a man is taken in adultery with another man's wife if the husband shall stab the adulterer or knock out his brains. This is bare manslaughter, for jealousy is the rage of a man and adultery is the highest invasion of property. Now, please see. So that is, my lord, the compelling object of the law, to preserve the purity of his bloodline.
Coincided with private property.
Chattel.
Because,
Chattel.
no, because the bloodline had to be preserved for inheritance.
Correct. Yes.
Ms.
Then, my lord.
Ms. Diwan, this Justice Chandrachud's judgment, para 135, protecting the purity of his own bloodline. There's a biological logic.
Yeah.
If man were able to procreate, this paragraph will not stand.
Yes. Then there are certain paragraphs on sexual. Now, my lords, please come to para 147. Because ultimately where this builds up to is to suggest that there is a right of sexual privacy both in marriage and even in choices outside of marriage, even if you are married. That is what it seems to suggest. So, 147. Moving on to the effectiveness of the provision at hand, the court remarked that criminalizing adultery did not help save a failing marriage. The court remarked that it was obvious that once a spouse was accused of adultery, the consequence was generally intensified spousal conflict, as opposed to the possibility of family harmony. Existing families face breakdown with the invoking of the right to file an accusation. Even after cancellation of the accusation, it is difficult to offer emotional recovery between spouses. Therefore, the adultery crime can no longer contribute to protecting the marital system of family order. Furthermore, there is little possibility that a person who was punished for adultery would remarry the spouse who had made an accusation against himself or herself. It is neither possible to protect harmonious family order because of the intensified conflict between spouses in the process of criminal punishment of adultery. So, my lord, everything is being looked upon from the prism of marriage. How to save the marriage? Can we save the marriage by criminalizing it? That's the whole, my lord, approach. Addressing the concern that an abolition of a penal consequence would result in chaos in sexual morality or an increase of divorce due to adultery, the court concluded that there was no data at all to support these claims in countries where adultery is repealed, stating, well, this is the South Korean law. Rather, the degree of social condemnation for adultery has been reduced due to the social trend to value the right to sexual self-determination and the changed recognition on sex, despite of punishment of adultery. Accordingly, it is hard to anticipate a general and special deterrence effect for adultery from the perspective of criminal policy, as it loses the function of regulating behavior. Now, my lords, please see, finally, at the middle of that page, finally, the court concluded its analysis by holding that the interests of enforcing monogamy, protecting marriage, and promoting marital fidelity balanced against the interference of the state in the rights to privacy and sexual autonomy were clearly excessive and therefore failed the test of these restrictiveness. Then, my lords, come the Ugandan constitution. Please look at 152 now. My lords,
main reason is that the view is was that in a civilized society, the male chauvinism has no room.
No, that is definitely
the reason in the other decision.
And chat women being treated.
Because see the ingredients to constitute the offense.
Yes.
Adultery. It was specifically considered. First one, sexual intercourse between a married woman and a man who is not her husband. Second, the man who has sexual intercourse with the married woman must know or has reason to believe that she is the wife of another man. The third one is important. Such sexual intercourse must take place with her consent. That is, it must not amount to rape. Another offense. Third one, that is the main thing. The last, fourth one. Sexual intercourse with the married woman must take place without the consent or connivance of her husband. After stating all these things, it was held. If a man has sexual intercourse with a married woman with the consent or connivance of her husband, he does not commit the offense of adultery. That means it is the man who decides.
Correct. Absolutely.
That is the point which was actually heavily criticized.
Right. But I only asked myself one question, that suppose...
So the consideration is totally different.
Yes.
In that particular case. Here, what you are investing is a totally different.
So we are concerned with operational imperativeness, readiness, efficiency of the armed forces.
That is why we use the expression male chauvinist.
Yes. No, my lord, it's even worse.
Whether it would constitute an offense or not.
But my lord, now
if
that
connivance is there, yes, you can.
My lord, suppose all these ingredients are met in a case today, can we not still punish for military indiscipline? Is it not unbecoming conduct? You may have
and a disgraceful conduct.
My lord, it can be even unbecoming conduct. It can be contrary to military
that is section 44.
Yes, it can be. It can be. That's the point. Now, my lords, what is coming in our way over here could possibly, because, my lord, the privacy right has been elevated to such a level for civilians, my lord, which we are not, no problem with that. Sexual autonomy in your partner, even outside your marriage, can this be, my lord, and this is attempted to be twisted around as a defense to, my lord's cases insofar as the armed forces are concerned under 45 and 63. So this cannot be elevated to that level when it concerns the armed forces. That's what we are saying.
Yeah.
Now please see 152, for instance.
There may be number of reasonings coming in different concurring judgments. Ultimately, what it boils down is that 497 has been declared to be violative of Article 451.
In the context of marriage, yes.
Whatever it is.
Yes.
It is reciting the rights of two individuals in a capacity as a man and wife. man and a wife. It will have been defined under the IPC itself. Now, what we are putting to you again and again is that you, as in your own discipline force, under your ambit of arms, army act or the Air Force Act, whatever it is, if you say sorry, I am not examining of an individual rights of a citizen, but I am examining rights of a serving officer covered by my act, unbecoming conduct of an officer for reason 1, 2, and 3, I am authorized to take disciplinary action or the action under the law permissible to me.
Yes.
So our request to you is, if you take that action, as Brother Joseph also suggested, this judgment is not coming in your way at all.
I'm only asking your lordships to simply clarify. So that's all.
This judgment never deals with the issue.
My lord, if your lordships say that, even that is adequate.
You see, your provision 45. Unbecoming conduct. Now, unless you must have defined somewhere what is unbecoming conduct.
My lord, it can't be
Broadly.
We have to.
Right.
It has to be flexible enough.
Give us,
it need not be
conduct.
only a sexual
Give us civil conduct rules.
conduct. It can be any kind of conduct. Which is
You have to. You can't be keep it open-ended.
No,
you have to define what, according to you, is the conduct
Lord,
which you expect
in
from an officer working under your disciplinary
My lord,
force.
there is a certain amount of intangibility.
Civil conduct rules.
Always,
Service conduct rules.
you cannot, my lord, we cannot say from A to Z, these are things which, there
You
are
define
things
anywhere.
which,
You define anywhere.
no, we cannot, by the whole idea of using such an expression is, there is a certain intangibility. Then somebody can say that if my lords, for something so trivial or inconsequential, if we have acted, then they can certainly challenge it. They can, they will have a full right to defend themselves. But obviously, my lord, I also
Whereas
understand.
you have perhaps one man is overdrunk. Okay. And he say from where you gather there is unbecoming conduct.
My lord, because it falls under a different provision.
So what we are requesting you,
It may fall.
you must have defined somewhere. Please ask them. What are the conduct rules, discipline rules under your services which an officer is supposed to follow?
No, it can't be defined, my lord, because in fact I'll show the judgments on that. Lord,
Perhaps you can give an answer to Justice Rastogi. Say, not walking in a straight line in the armed forces, it would be an unbecoming conduct. Although it is not a defined thing that you have to walk in a straight line. In a given situation, when you are marching, you have to walk in a straight line. So if you don't walk in a straight line, it is a breach of discipline.
but it has to be of a. It has to be so out of character to invite that.
Out of character for an armed person.
For a yes.
Suppose civilian doesn't walk in a straight line.
It doesn't amount.
It doesn't.
That's one of the example which I gave was a sentry who is sleeping on his post. If he is drunk, if he is intoxicated on his post, it invites some 14. It can, I mean, not that it's been done, but up to 14 years. Now you may think that is extreme, but in an ordinary civilian situation, but this is what we believe. But we cannot define everything. That flexibility, in fact, judgments also recognize.
That may be the reason for enactment of section 63. Because you may not be in a position to envisage everything.
Correct.
That may be the reason under section 60.
Yes. And this is also a classic.
Therefore, the question is whether that particular prejudicial activity is against the good order or military discipline.
And nobody has challenged the validity of these provisions in any case. So.
You can even be visited with death if you sleep in the army.
Yes, my lord, it is.
You just see section 34, subsection K. You sleep in the army, you can be visited with the penalty of death.
While on active service.
Subsection K.
Yes.
He essentially at the time of war or alarm sleeps upon his post. Or is intoxicated.
My lords are reading 34.
34K.
K, yes.
Because that's a need of the force.
My lord, it's in time of war.
It's a time of war.
In relation, these are offenses in relation to the
If
enemy.
you happen to sleep, can theoretically be visited with death.
Theoretically, yes, certainly, my lords, yes.
You sleep in the army.
You sleep when the enemy is at your
Exactly.
door.
You're supposed
Can't
to-
do it. Yes. So that's why, my lord, nobody is going to, in a civilian situation, you can never imagine.
Let's come to something different.
Yes.
Now, what really is your problem? You're invoking 4563.
Yes.
Now, you're proceeding with it, you're taking action, you're dismissing them or doing whatever you're doing with them.
My lord, it is
Convicting them.
stuck at so many levels because the moment a charge sheet is filed under 45 or 63, immediately it is challenged. Then it goes to the AFT. Then depends on what happens. So it's this uncertainty is delaying my entire process. So they're still serving. They can't even be suspended.
In any one of the cases, as it independently reaches this court,
Lord,
where this court could certainly, clarify with reference to the fact of that particular case,
Lord,
that really does not, it's not a case covered by Joseph Shine. You have independent.
Lords, I would. There was one case which came up where, my lords, in fact, there was a limitation issue over there. So, my lord, that failed. But, my lords, I would say this, my lord, very respectfully, that now, my lords, that the matter was referred by 3 judges to 5 judges, my lords. This deserves to be taken to its logical conclusion, and the reason is this. Lord, we cannot afford this kind of uncertainty or this kind of delays in the process where a spate of, and there are so many in the pipeline still, so many happening, so many not even, my lord, charge sheeted, and my lord, this puts a dampener on our actions also. So we do need that clarity that once and for all, once 5 learned judges decide that did not deal with the armed forces, my lord, that is the end of the matter. We can act today. We may not be able to suspend. Tomorrow, my lord, if those officers are acting and there is insubordination in the unit, my lord, the consequences can be in the meantime very serious.
Do you want actually a kind of declaration?
We want
What an advance ruling.
Yes.
my lord, we want, my lord, even if your lordship that if this judgment was not concerned with armed forces, that is, I think, quite sufficient. That we are free to act under our military discipline. That is, my lord, would be quite adequate. Because everything being held up at so many different levels, and my lord, there's so much litigation.
All the persons who are parties in the individual litigation, are they before us?
3 of them, I think, my lord, 3 of
Some of them are here.
2 of them, yes.
Some of them are here, but not one out of the many who are actually subject to those proceedings are here.
Yes,
So
they are.
would we not end up actually doing something behind their backs?
No, my lord, the question is that they are, your lordship is only clarifying a judgment. It so happens they have come as interveners and their interventions have not even been allowed.
That's right. So, but then when we are clarifying, they are doing something behind their back. So they are clinging on to Joseph Shine as the bedrock of their defense. Because they say that this court has declared the ingredients of 497 to constitute an offence which is unconstitutional by Article 14, 15 and 21. Correct. What you are trying to do is you are sort of cloaking it, you are disguising it as a separate offence. Because of the
There is no disguise, my lord.
words unbecoming conduct, and you are saying you can package it under unbecoming conduct because it's a separate offence, and you're in a workplace and you've got a different unique work culture, code, exhaustive code. Therefore, it should not apply.
Lord, please see my difficulty. Earlier, because 497 was there on the statute book,
Yeah.
I had to go under 69. I
That's-
had to go because it was a civil offence. Now that it is not, otherwise I would have been free to go under the other provisions.
Civil offence.
So I was also, my lord, precluded from moving under, my lord, going under in that sense 45 or 63. Today I am doing it as I was entitled to. There are other jurisdictions in which, my lord, similar provisions have been invoked. It is unbecoming conduct. It has been dealt with, my lord, even in the United Kingdom as unbecoming conduct. So, my lords, today how can when a judgment was not rendered in a particular context, it is causing, my lord, serious confusion within the armed forces as to this needs clarity, and only this court can decide that. There's no question of being behind their backs, my lord. They will have every chance at that stage to say that this is becoming conduct. What is the problem with that? They can say that no, you could not have abrogated my fundamental rights.
When the both say what is becoming conduct is legal conduct.
It is, my lord, it is not criminal conduct in 497. 497 is not criminal conduct. That's all in this civilian context. And 45 itself is, my lord, cashiering in any case. It's not criminal. 63, yes, there is a, but my lord, if I am protected by an umbrella provision, I cannot be precluded from approaching, from taking action against that. And how can, my lord, in the entire country, there may be hundreds of people who are going to be acted against under these provisions.
There, Justice Bose has perhaps a solution which he found out at the very beginning, which is seek shelter under 33.
Yes.
And incorporate the ingredient of 497 as a separate offense. Because it will not have the protection of 14, 15, and 21.
My lord, till Parliament can act in the matter, my lord, can we brook this kind of delay in the armed forces when we have clear provisions? There's an existing law. My lord, how can we brook this kind of uncertainty and delay in such a situation? Where the court clearly, in our respectful submission in Joseph Shine, intended something else. Clearly, it was a very different context. And today, my lord, it should imperil military discipline. That was not.
We are facing is we don't seem to be having a cause of action. So far as this order for clarification is concerned, no court has held that because of Joseph Shine, you cannot take step under this two provisions, 45 and 63.
My lord,
so in that sense, why should we presume that the courts will hold that you cannot take such steps?
My lord, the court. I'm so sorry, my lord. Yes. And then eventually on limitation.
If any matter is pending before this court on this,
there was, and on the last occasion when this matter had come up, there was one matter. However, my lord, but my lord, please see the message that is being sent out. The matter goes from a 3-judge bench to a 5-judge bench, and then, my lords, without a clarification, my lord, it would create so much confusion, and how much advantage will be taken.
Clarification. What we are saying that we don't have any material which shows that Joseph Shine applies to.
Well, that's good enough. So your lordships may simply say that and dispose of my application. It does not apply. As simple as that.
We can't say whether it applies or not. We say we don't have any material.
We just have to say that Joseph Shine was not concerned with section 45 and 63.
My lord, that is good enough. That is good enough.
Not concerned with 45 and 63 at all.
And the corresponding provisions of the other act.
Yes.
Concerned with that.
That is more, my lord, that is adequate. That is
a fact.
Yeah, that's a fact.
Shall I now make a short reply to the petitioners? Because I have told I was appearing for Joseph Shine. And therefore I may
not concerned. The court was not concerned with those provisions.
45 and 63. Whatever will happen in a particular case, you have to take it on its own merit.
That's what I am saying. Shall I make a very short reply?
You're satisfied with that?
It was not that the court in Joseph Shine did not consider and was not concerned with these provisions of the.
That goes without saying. That goes without saying.
Can anyone have any objection to that clarification?
May I just?
Shall I now make a submission? Since I was appearing for Joseph Shine, before the interveners, I may be heard.
We give preference to those who are appearing flesh and blood before us.
What I am submitting, my lord, just bear with me for a moment.
Let the lady speak first. Let her speak first. There is somebody in front of you. Let her speak first.
Shall I make a very short request, madam?
No, please
Shall I make
wait.
a very short request, madam? I won't be taking time. I am only suggesting certain things which your lords may kindly bear with me for a short time, because after all I was appearing for the
We'll hear you,
petition.
but let her speak. Let the lady who is before us speak first. We'll hear you. We are not saying we're not hearing. Yes, what do you say?
My lords, only 2 points. One, that the fact there is no need for a clarification. The judgment speaks for itself insofar as it doesn't consider.
What does the judgment speak for? Does it speak for about 45 and 63?
It doesn't.
Therefore, we are only saying
My lords,
that this court was not concerned with 45 and 63.
would my lords then also clarify that whether those provisions need to be invoked, needs to be decided by the armed forces in the given facts and
Oh, why should we clarify
My
that?
lords, I will point out why, because in this order that my lords are proposing, it's effectively the clarification that they have sought for, and they would, in that case, without application of mine, invoke the provisions pertaining to adultery in each case. My lords would allow me to.
You can challenge that, or rather, you can question that
My lord,
action inappropriate.
in giving this a clarification of this nature,
See, again, now you are asking for advance ruling that Joseph Chain applies.
I am not.
So you can't do that.
My lords, the premise of the arguments is on the basis that there is Article 33 that is applicable. There is no statute that has been drafted and passed by the Parliament, pursuant to which there are provisions made for the purposes of punishing personnel for adultery.
Is it becoming conduct
My lords,
for an officer to engage in adultery with somebody? Is it becoming conduct?
no, my lords, it is not becoming conduct
It is
possibly for anybody, whether that
No,
person is serving or
They're not
otherwise.
talking about anybody. They're not talking about anybody, because anybody is not concerned with unbecoming conduct. You're a member of a discipline force with huge ramifications for the rest of the country. You're supposed to actually guard our boundaries. If you're busy doing something else most of the time, and if you send the kind of the waves down your ranks, that this is okay. And brotherhood, that oneness that we spoke about, what will happen to all that? So what you're saying is, it is unbecoming conduct,
My lords,
not becoming conduct. I mean, let's be very clear about it.
See, at one time, one couldn't send a letter to an army officer at the field station. It had to be army post office.
it continues to be my
That kind of privacy rights have not percolated.
My lords, who are
Directly.
restricting the rights of Joseph as a judgment,
So-
my lords, does not restrict the rights of the husbands who are serving.
We are not on, so far as army is concerned, Joseph Shine did not consider the provisions of this 4563 and equivalent in the other 2 laws.
Yes, my lords.
So, if we just record that, then you fight your own battle whenever unbecoming conduct question is raised and you are arraigned for having committed that unbecoming conduct.
My learned friend, in fact,
That is alleged. If that is alleged and forming a part of a charge sheet against you, definitely you can.
would that, is there a necessity to go to 45 and 63, my lords? 46 provides for disgraceful conduct, my learned friend, the manner in which it was.
See, we do
45.
not know because we are not dealing with individual cases. There is a constitutional judgment which has come. Army feels, the defense forces feel that the judgment is being construed to kind of tie up their hands in dealing with disciplinary action against their officers. What we are contemplating, saying is that Joseph Shine does not deal with has not dealt with the army laws, and so there's no clarification on that count is needed. Let the individual cases be contested in their own merit. Because again, as my senior brother pointed out, 497 is only concerned with intercourse.
Yes, my lords. 497 is.
The unbecoming conduct may be of wider ramification.
I appreciate that, my lords, and I agree. All that I am saying is, let that not be used to reinstate 497 by separately classifying of.
We are not saying that also. What part of 97 is used, whether it's a platonic relationship is prohibited or not, we are not
Because 497 as a concept, after it has been set aside by my lords, there cannot be a situation that it can be reinstated only for a class of persons, whether there is a classification available. That is all that I'm saying, my lords, that it should not be a way for reinstatement of 497 because that issue, my lords, is not considering today.
No, because Joseph Shine also did not consider that issue.
Because that issue, my lords, doesn't arise. May I just explain why?
It doesn't arise. Then why are you so concerned?
Because it would be a way.
You want to.
I am not asking for an advance ruling. All that I am requesting, my lords, is a clarification that my lords may consider incorporating that each of these cases may be dealt with on the.
So you are also seeking a clarification.
If there is a clarification to the effect, my lords, that 497, the impact of Joseph Shine there would be no impact of the judgment of Joseph Shine on the persons to whom Army Act, Navy Act, and Air Force Act applies. Then each of those cases might have to be looked at in the context of whether the conduct actually is unbecoming or not. Because unbecoming conduct has to relate back.
That's not the issue.
It has to relate back to the services.
What is your name?
Ananya Ghosh.
Ananya Ghosh, when we come to the prayer and the clarification, what they have sought is something a little bit more expansive.
Yes, ma'am.
So that's a person subject to so being a distinct class, any promiscuous or adulterous act should be allowed to be governed. So if we are not saying that, we are only saying that Joseph Shine was concerned with what do you call it, 43, and the court was not concerned with 43, 63, other provisions of the Army Act. And we leave it there. How can you say that we are doing anything by way of reinstating, we are putting...
No, my lords, I am not saying that my lords are reinstated.
And since you are...
I am apprehensive.
Also saying it is not becoming on there.
Whether a set of...
You have not yet made up your mind whether it is becoming contact or...
Let me be very clear. Whether the judgment itself recognizes that there is a moral wrong that attaches to an adulterous act. Whether such moral wrong is unbecoming conduct, and that scope, I agree with Mrs. Devan, is very wide, and it needs to be wide because it has to address circumstances as they come. It is not possible for the armed forces or the Ministry of Defense to set out certain circumstances and define it categorically to say that these are the 4 circumstances which are unbecoming conduct. Equally, my lords, the statute as it stands does identify significant of them. Intoxication, unnatural conduct, cruel conduct, all which are defined. But we are not going into that discussion today. My concern arises.
This is another thing. 497 is dealing generally, as you say, with the government, whether he is employed, not employed, etc. When you're talking about somebody who is governed by a separate set of rules, because it's an exhaustive code, as Dr. Kumar pointed out, then when you enter into employment, it's not a contractual affair, as you know. You are elevated to the status of, there is a status too.
Definitely.
When you are a member of the army, when you become a member of the army police or the armed forces, there is this aspect of the discipline that you have to follow. So therefore, as part of the discipline, what constitutes separate offences at the various, because they have taken care after providing for civil offence under 69 to also provide for unbecoming conduct. So 69, you bring in 497.
It may not be true.
That is civil offence. Now the civil offence needs to be, because it cannot be there also not lying on. But is that prevent them from relying upon unbecoming conduct for the purpose of maintaining discipline in the army? See, the whole thing is somebody who is not employed at all, he is free to go have adulterous relationship, whatever. He doesn't have any repercussions outside of his life, individual life. A person who is subject to the discipline of the armed forces is not similarly circumstanced. Because what he does not do has a repercussion on
the entire unit.
Entire unit, and not only the entire unit.
Possibly the country.
Peculiar way to the country itself. Because it's related to the discipline that you maintain. And also, it is not there the other problem was there about the gender partiality. Here it is gender neutral because the word his can always be under the general clauses. The officer can be read as including a female. Now it will say his. You read 45, it says that officer his. Under the general clauses of the act, you can make it her also. So irrespective of who does it, whichever officer does it. Because it is not becoming content.
My lords,
Yeah.
we are today.
So
And I
you have a
am
problem
not-
with that.
No, my lords, I don't.
Different
have a-
setting.
No, my lords, I don't have a problem on that count.
Yeah.
And the reason I am not addressing that point is very simply that today am not entering into whether adulterous conduct is becoming or not. It is, personally speaking, it is not becoming conduct. It has been recognized as a moral wrong. It is wrong, therefore it forms a ground for divorce. Otherwise, it would not form ground for divorce. All that, my lords, I was requesting is this. When my lords dispose of this clarification application, observing that the Joseph Shine judgment did not have cause to look at any of the statutes, my lords may additionally clarify that where these provisions are sought to be applied, they would be applied on the facts and circumstances of those cases without reference to section 497.
497 comes in only in 69. 69 they are not invoking.
They are not invoking 497. What they are seeking to invoke are the principles of 497.
Yes. For the purpose of maintaining discipline in the army, not for regulating your private life.
Not 497 in its form, it was reflected in the Indian penal
See, a
code.
distinction between somebody who is employed, not employed. The first distinction. The second distinction, the nature of your employment. If you are employed in a sensitive, highly sensitive force like the armed forces, you will have an exalted, elevated level of, the standards,
My lords, I appreciate.
which are geared to actually achieve a particular object, which nobody can question.
My lords, I don't question. I come from a family of service personnel, so I don't question it.
That's good.
The reason why I'm pointing out what I was pointing out is this, that the premise of the application is to ensure that the family of service personnel are not engaging in untoward behavior. It is that the family of the service personnel posted at the borders are not engaging in untoward behavior. That is the premise of the application. It is not my premise. It is categorically stated to be so.
If the premise is that, the person, who's the husband? If you just check up, if you just see the figures, the man, W the wife, and X the husband. These are the three characters in 497.
Yes, ma'am.
Correct? If you juxtapose that in the context of 43 and 45 and 63, how would you do it? There is a man who is working in the army and an officer.
Yes, ma'am.
He has an affair with W, the wife of somebody else, and then the husband, or the family whom he represents under 198. RPC or 198 says only the husband.
Only the husband can complain.
That is also struck down.
Yes, my lords, because that's a consequential relief.
That's right. That's right. Now here that 198 read with 497 scenario is not relevant.
69 is no longer relevant because 497 is no longer part of life.
What you're saying again? See, what does 497 say? That when an offence is committed, not anyone can go and complain.
Only the
Only
husband
the husband who can go and complain.
in recognition of the shackle principle.
Correct. So, does it require for the applicability of 69 when it was when 497 was on the statute book that actually a prosecution must be commenced or a complaint must be filed by the husband?
Complaints
Or is
could
it
be-
sufficient that it comes to the knowledge of the army that an incident has taken place?
My lords,
Not
incidentally,
required. It may not be required.
incidentally,
If the army
complaints were
comes
made
to
by the
prove that an
spouses.
offence has been committed. The 497 read with 198 is for the purpose of setting the criminal law in motion.
Yes, ma'am.
The only person who can do it is only the husband.
Yes, ma'am.
As far as the armed forces, Army Act invoking 69, it's only that offence is committed.
Yes, ma'am.
nothing to do with the enforcement of, the right with the husband to, he may or he may not. He may acquiesce. He may say, I don't want to, take this matter to court. I may forgive her, I can condone it.
Which my
relevant is
learned friend anyway indicated that it will still continue to be an act of becoming correct. Because that has nothing to do with the adultery as an offence under 497.
That's right. Because therefore the context of, even 497 is completely different when it is transplanted and when it is operated within the four walls of the Army Act or Navy Act. It's got a different repercussion, different connotation. Because your conduct, as you said very fairly, because you are from the armed forces and family also, you say, then what you do, you are actually the public figure, not a private life, somebody's private life alone. You are actually commanding a particular unit, you take it. The word will go round so fast. See, our man is doing it. So let us also, another thing is that it is infectious. See, what is immoral, what is immoral, what is wrong, what is good. You may be relative values, but in the armed forces you have a particular discipline. Because why? Because the nation might be confronted with a war at any stage. If you are going to have an army where you have completely loose morals, where you say, okay, sab chalta hai.
My lords, it's actually
what will happen to the discipline of the army? Just think of it.
I don't think that's either the mandate of the judgment in Joseph Shine or a statement that I am making for the respondents.
That is why we say that it was not concerned with 45 or 63, which is a truism, which what you're saying is not anything which is wrong, as a matter of fact.
Yes, ma'am.
That's obviously.
It is, yes, my lords, that, and if my lords can still consider putting in a sentence that as and when these provisions are sought to be invoked, they would be invoked, taking into consideration the facts and circumstances of individual cases.
Actually, they can do it only in that way.
Can
they take it as some kind of a general Euclid theorem?
My lords, it is actually
it is to be done on the basis of the facts in each case.
My lords, it's both are broad provisions. They are actually invoked in almost each and every case, along with other provisions, because they are broad. Every conduct, whether it is a breach of any other provision also, is good. Let's say it's a case of intoxication. It will always invoke 45 and 63 because that conduct will, if it's an offense under your statute, it is a conduct that is considered to be unbecoming. So the provisions are invoked in each and every case, almost as a matter of course. Therefore, my lords, it's a request if my lords would consider while disposing of that, it may be clarified that the invocation would be on the facts and circumstances of each case and not as a matter of course.
Ms. Ghosh, I don't think the Joseph Shine judgment, I mean, if you leave aside, 4 different judgments written, what it has done, it has simply decriminalized Section 497, whatever the act that is envisaged under Section 497, that has been decriminalized, right? It's no more a criminal act. Now, suppose any conduct of a person belonging to the armed forces are coming within what is prohibited under 45 and 63 and parameteria provision, that is not being taken away. You have agreed to that. No, you have agreed to it, right? So if such a clarification is given without the additional clarification you seek that it will apply to each facts, that is not necessary at all. Why is it necessary? Because if they put a man in the armed forces on charge of committing breach of 45 and 63 without bringing in what was contemplated in 497, how you are prejudiced? Or how your client, the client that you are representing, is prejudiced?
My lords, my submission is only this, that it may be recognized that it has to be on the facts and circumstances of the cases.
No, that is otherwise also.
Any promiscuous act, because end of the day, when it comes down to 45 and 63, any act that is complained of must necessarily have a relationship with the duties they are required to discharge and military discipline. That they will still have to establish. It cannot be that this order is shown and said that this order permits us to invoke and we have therefore invoked without showing the necessary nexus between the military discipline concerned and the good order, which they still have to establish. The
No,
act
that-
doesn't say that though.
We are slightly on different. We have coming into a bit.
Yeah, we have to come.
So, what Joseph Stein says is decriminalization of 497. Nothing addition further. We are talking about armed forces. Let us take in general. This discipline is required everywhere where you serve. In any capacity you serve. Now, if your conduct is unbecoming a conduct to serve the institution, wherever you serve, and the authority in its wisdom within the parameters of unbecoming conduct of an employee or an officer holds you guilty without aid of 497. And according to the service jurisprudence, this is sorry. This, according to us, this relation is unbecoming conduct of an individual. Why can't, where is the restraint come from the judgment? Nothing.
There is no restraint from the judge.
No restraint.
In fact, that's our position.
No criminal action can be taken against you, an individual, whether in armed force somewhere. But
I
if,
see criminal action.
but no, not criminal. They are taking the action under their own law. Under their own law which permits them.
Which, if they are able to establish that a conduct in question impacts military discipline and good order of the services, which in different words are provided for in the 3 statutes.
That's correct. And they take action under their own law.
They are taking action under their own law as there is no quarrel on that, my lords. We are concerned about, our apprehension is that a clarification would allow them to override the requirements of looking at the mandate
You
of
are presupposing something which is still not there.
We'll come back after that. Who's been 215. 215. 215. 215.
It is introduced, I believe, in Parliament in the second.
Filed an affidavit, Manoj, that new data protection bill, which might cover most of the issues, Manoj, being heard. Is being introduced subject to administrative approval, etc., some formalities. In the second half of this session, the session has started from today, the second half would start from 13th.
Well, our request is that let the bill come, because it will be before you, and then the matter can be taken.
Because on behalf of the petitioners in the lead case,
yes,
I'm opposing this application. This was mentioned to your lordships in September when the matter came up. It was meant at that stage there was no bill pending. The history of the last bill which they introduced, because in fact there's an order in this matter where in 2017, Mr. Mehta had informed the court that time when a committee was being set up that it may translate into a law. So that was 2017. Then even in September, it was mentioned that there could be a bill. The fate of the last bill was that the bill itself was withdrawn. And your lordship knows that even after a bill is placed, it sometimes may get referred to a committee, etc. There may be deliberations, etc. So the introduction of a bill itself, assuming what they say is correct, and I have no reason to doubt that they are proposing to introduce it, shouldn't defer or delay the taking up of this case. The lordship will take up this case and then we'll see as to what is to happen in the matter. Let us open and conclude. We'll assist the court as best we can.
I'm in 502.2, where the issues do not pertain to the bill at all. The issues are threshold issues of reviewability of actions by private parties. So bill or no bill, that issue is before your lordship. So I'd urge your lordship to hear that issue.
I also place a corrected matter.
I have the statutory mechanism in before your
an academic exercise.
Judicial review of what?
Of judicial review of actions by non-state actors. That's the issue before your lordship. That doesn't pertain to the bill in any way. It's not germane to the.
That is also referred to.
That's before your lordship.
Well, that non-state actors also part is also covered.
Even in the main petition that Mr. Diwan is leading.
Is it in connection with this WhatsApp?
Yes, exactly, my lord. The position is what we are advancing.
Supports Mr. Diwan's submissions. I'm geographically standing here. But my purpose is not that it might be an academic exercise in absence of any statutory framework before your lordship.
Whereas what will your lordships decide? Whereas in the absence of the formulations, of the government, which are very complex formulations, in the context of the experience.
I'm sure the government will frame it. We have been waiting. Your lordships have placed the matter now in this month, and it is coming up. So let us wait our turn, and we will assist your lordships when the matter is called out.
This kind of matter
Yes.
Sorry. You are right in saying that just because a bill is introduced, that it will immediately result in an act. You are right in that.
Yes, it may not. The bill may not carry.
May not carry also.
Exactly.
And it might be referred to.
And our grounds are independent of any statute being passed.
I would understand that.
Right.
But what we are trying to suggest,
yes,
rather looking at,
yes,
is that a legislative framework,
yes,
if it is available,
yes,
and if the government is contemplating it,
Right.
Then should we now do this exercise? Because
most definitely, according to me, yes.
These are not
these
are not easy exercises to be done. So therefore,
no, I agree with you.
The government has taken a particular conscious call to introduce a bill. I think legitimately for a reasonable time, I think we can wait certainly.
Anyway, I will make.
I've been waiting. I'm just asking.
I'll make two submissions. This is a writ petition which relates to the year 2016. Correct. It's a 2016, and thereafter there was there's a judgment of the Delhi High Court which is in challenge in appeal here now before this court, before a constitution bench. So that will have to be considered on whether it is right or whether it is wrong, the validity of that judgment on the basis of the grounds which we put forward. Now, doubtless, as to what your lordship says, that if there is a statute which comes in at some point of time, it may have an impact eventually with regard to how certain persons who are operating, including WhatsApp, operate, whether they can trade their information or not. The bill which is in the public domain and available to us, etc., for comment, etc., and in fact their last affidavit says that they are collating the comments and then they will synthesize them and then probably place them as a bill. That has no impact insofar as this case is concerned. There are generalities and provisions in the bill which have no direct impact as to what the issues which we are proposing to canvass at all. But I don't want to second guess as to what the government eventually introduces and what eventually comes to be passed. I mean, that is not in our realm. So we have a case. It's been referred to a panel of 5 judges, a constitution bench. We are anxious to go ahead with this particular case. I'm not for a moment doubting that if a law eventually comes to be passed on data protection, it may have some impacts. But that's the nature that's the manner in which our system functions. You have laws, you have systems where the court pronounces on the law. But just now to short circuit it at this stage, I don't think is appropriate.
Well, just to add to that, because this bill has been pending since 2011, and even if today the bill becomes an act, then because what will happen is that so since 2011 this exercise has been going on, and even if the law comes today, Milods, what will happen to the time where all this vacuum was there and privacy violations have taken place? Because the legal provisions would be prospective only.
You are right in saying long pending, it has to be heard, undoubtedly.
No, and your lordship recalls in September, they made the same request. We said we'll put it in January. If no bill comes by or no act comes by, then we'll proceed.
You are right in saying, but once they've been informed about the bill is there, it will also assist us also in taking a final call after you come on record. You may make your submissions as to what
a bill, Manoj. It's not going to decide on a bill.
Ultimately, it will assist us also.
We have circulated issues to ask it for all to examine the issues and decide whether they pertain to the bill. As part of
what are the core matters?
Yes, in 502.2, in which I appear, my lord, the core matter is WhatsApp's privacy policy, which the petitioners generally believe violates users' right to privacy.
I support them on that.
Now, in that context, there is
in favor of the intermediaries.
In that context, there is the bill, but there are threshold issues to the bill. One of those issues, which was recently
privacy policy, is covered by the bill,
which was recently decided by
this is not WhatsApp
in a 5-judge bench, was whether Article 19 and 21 was whether Article 19 and 21
to do with WhatsApp.
It's more to that, immediate intervention is required because day by day, minute by minute, rights are being infringed. Their personal data is being disseminated.
My learned friend should tell me one individual out of 600 million who says that this right has been violated. Not one.
Well, that's admitted case.
Let's not go into that.
It's a Mark Zuckerberg statement before the US Senate. Admitted case, there was data leak.
If your lordship
Cambridge Analytica was
it will be an academic exercise.
In a housekeeping situation, so much heat is being generated.
It's only housekeeping. Understand? It's about the issue.
Not at all.
May I make a suggestion? Here we have interrupted an ongoing matter which is before the Constitution bench on a mentioning by the other side. Let us wait for this earlier bench to, we are the very next matter. When our turn comes up, we'll assist your court and be in a, yes, very well.
You're interfering in the middle of a year.
No, Manoj, we are just better. Manoj, your lordship, we wanted to inform you that this is going to be a submission, Manoj, and we will.
You're interfering with the partnered matter.
No, I don't. No. We are not here to interfere with any.
You know that an indulgence.
Yes, sir.
Only one thing, not for clarification. We would not, we are supporting the privacy policy and we are with the users and we are not with the WhatsApp or anybody, but the bill, not the hearing before your lordships would be confined to either WhatsApp or it is intermediary centric. Intermediaries are 7: WhatsApp, Twitter, Facebook, and large number of others, which we perhaps may not be aware of. We'll not assist you.
Primarily to WhatsApp and Facebook.
No. There is Google.
Seminal one for
instant.
Somebody is talking.
There is Twitter. There is Google.
Somebody is talking. Just they don't do it. But question is of few weeks. I leave it to you. Because I say, it would be coming in the subject to the administrative procedural issues. We would be coming in the.
Let us not do anything when we are in the middle of matter. We are not going to do it on mentioning this man. Your interest is after this matter is over.
Yes, grateful. We'll be here.
Yes.
My lords. Yeah, my lords.
Yeah.
My lords, it is a matter of fact that the Joseph Shine judgment did not deal with any of the other statutes. It was only concerned with 497 of IPC and consequently 198 of the Criminal Procedure Code. Nothing beyond that. My lords, subsequently, a matter came by way of an appeal to this Honorable Court, where the provisions that the Honorable Court were concerned with were parliamentary provisions, but under the J&K Constitution, the Ranveer Penal Code, not the Constitution, the Ranveer Penal Code, where parallelly provisions of the Army Act under Section 63 were also in. My lords would see the judgment part where the appeal was concluded, and it was held.
Which can be imposed as a result of 45. Take for example 45.
Yes.
What
Cashiering or dismissal. Cashiering or dismissal.
That's it. I'm just saying.
Not imprisonment.
They invoke 63, 7 years.
7 years imprisonment under 63.
No, what 45? What is the punishment?
45 is cashiering, which is dismissal with dishonor.
You're
Dismissed with dishonor. With dishonor. Dismissed with dishonor, that's cashiering. And then.
Where do you get that? Where do you get all that?
My lord, the definition of cashiering is not under this. Where are the
You're saying
It's in 45 itself. Cashiered, the word is used, it's a term of art so far as we're is concerned.
It's not defined here, but it basically means you are dismissed.
Cashiered is you dismiss, you don't get benefits.
It's an ignominious form of dismissal, and then, or to suffer such less punishment than the act. And if he's a junior commissioned officer or warrant officer, be liable to be dismissed or to suffer such less punishment as in this act mentioned. Now, that other provision for less punishment would be in 71. Lord 71 talks of D is cashiering, E is dismissal, F is reduction to the ranks or to a lower rank.
One more thing, if you read 45, liable to be cashiered or suffer such less punishment as in this act mentioned. What
That's 71. 71.
70. Let us
So
see what.
we have to look at less than cashiering or dismissal.
Let us see.
So please see 71 D is cashiering, then E is dismissal.
71.
71, yeah. D is cashiering in case of officer, then E is dismissal from service, F is reduction to the ranks or to a lower rank or grade or place in the list of their rank in the case of warrant officers, and reduction to ranks or to lower rank or grade in the case of non-commissioned.
So what we are trying to tell you is not exactly setup of a criminal trial where the punishment usually is part of either imprisonment.
63. 45 is not, even though it's by a court martial.
Therefore 45 read with 71E onwards. I mean, sorry, from E onward.
It can be reprimand. It can
be a disciplinary procedure.
Yes, it bears the character of a disciplinary.
5 years imprisonment.
So always evoke 45 read with 60. They're all people who are convicted under 45 read with 60.
If they do it only on 45, what you're trying to say, 45 is either cashiering or something less.
Something less.
Not any punishment.
That's right.
It's a criminal trial. That's right. If you wanted to
But it's
understand.
through a court martial. But through a court martial.
That's right.
One question, suppose if a man and a woman, take one, the man is an employee or both are employees, they are engaging in an activity constituting adultery in the premises of that very institution. And after the working hours or during the working hours or before the working hours. And then see whether you will say that since it is that particular act is decriminalized, they can do that with the impunity and then escape unscathed. Or whether you will say that the employer is free to take action, initiate action for an unbecoming act. What is your?
Submission is simply this. Insofar as conduct workplace is concerned, workplace belongs to the employer. There is nothing. The Joseph Shine judgment doesn't come in the way of the employer making a law.
So merely because that particular act is decriminalized, the very same action.
How? If there is.
See, that can also be a reason for holding them for an act which is unbecoming conduct.
My lords, let's take a simple example.
No, that is why we put this example.
I will take a
very same action in the premises they are doing it. Can they simply say that this is decriminalized and therefore we can do it with impunity?
My lords, there is no question of impunity or otherwise.
So therefore there shall not be, for that particular action, there shall not be any action. Can you say that?
Submission to that effect.
If that acts constitute an act which is unbecoming of an employee, why you will say that no, they shall not be permitted to take appropriate action in accordance with you?
My lords, our submission is not that. Our submission is simply at the context of the prayer that has been made by the applicant here. The prayer by the applicant is slightly different, if my lord.
We have indicated roughly that what we might do.
My lord,
that is acceptable to union. 197 is differently and particularly structured provision.
True, my lords.
It's not even a general offense like theft or something.
My lords.
Here it's the permission of the husband or whatever for adultery. All that things are involved. And the reasoning of the Constitution bench was that patriarchal elements in the provision itself.
My lords, if one were to look at Joseph Shine, shorn of everything else, there are two premises on which the provision is struck down. That provision is found to suffer from manifest arbitrariness in the manner.
Discrimination.
Manifest arbitrariness and discrimination, both, my lords. Manifest arbitrariness, therefore, invoking Article 14 in view of the manner in which the provision was set. That only a certain person could be punished for the offense, only at the behest of a certain person, there is a manner that person who claims to be the...
Yes, but it would be speculative on our part to presume that this 45 and 63 would be employed only for this kind of
Manoj, we are not. Manoj, may I just...
So what is your concern?
Manoj, to be that, if we apprehend that once an order only to the effect that is given that the judgment in Judgements did not concern itself to section 45 and 63 and equivalent provisions of the other statutes. Ground on the basis that there is a mandate of this court that that personnel who fall within the purview of the statutes could be prosecuted for offences equivalent of adultery, promiscuous acts, as has been prayed for in the application, and they would be proceeded against. We would be, were my lords to consider passing an order to the effect that no clarification is required in the terms that are sought, and that the Joseph Shine judgment does not concern itself with any other statute apart from section 497 and 198 of CRPC, I believe that there would be no issue.
We put a simple example to you. Supposing tomorrow an officer is charged under 45 with an act which amounts to adultery, as it is understood in 497. Correct? And it is described that this amounts to unbecoming conduct. Correct? Now, can the officer say, because 497 has been struck down, I cannot therefore be charged with a conduct which, for the purpose of the offence under section 497 under the Indian Penal Code, has been struck down, and therefore section 45 has become a dead letter. Unbecoming conduct must be something else.
No, Manoj. That is not our...
Can you do that?
No, Manoj.
Simple question we are putting. Can you do that?
No, Manoj. Because section 45...
If you can't do that, please clarify that.
That's all, Manoj. All that...
You'll be in a worse position than what you were.
Yes. No, Manoj.
We will clarify that. We'll clarify that.
Manoj.
You are very correctly answered because you are led by your truthful estimation of what you understand.
My lords, all that I am saying is, would my lords consider just adding one sentence?
The example we gave you.
My lords, 45, there cannot be a so long 45 is invoked in a circumstance where the forces are able to make out a case that the conduct in question is unbecoming of an officer, that stands on its own plan.
No, that we'll have to be there. You are little bit you are not answering. We are saying he is charged with the offence of unbecoming conduct of an officer, which ingredients are that which are borrowed from 497.
We'll take the simple example that there is promiscuous conduct by the person.
Promiscuous conduct. Or it is adultery.
Yes.
We are saying adultery. We are saying right royal way. We are saying adultery. And they bring it under the 45. Then can you be heard to say 497 of the IPC has been struck down by this court. 45 therefore is eclipsed permanently, goes into a limbo, cannot come back ever, cannot be used. You go around merely committing adultery. No. Your officers and the rank and file, they are led to believe we have an officer who's thoroughly immoral. But nothing can be done about it. Huh?
No, my lords, that is not our...
No. What else do you want? What else are you suggesting?
I am not suggesting...
Are you not suggesting that
not
exactly?
Not at all, my lords.
Yes.
I am in fact...
What should the disciplinary authority do when an officer, a responsible officer, bound by the Army Act, commits adultery? Are you saying that their hands are tied, fold, you cannot do anything? Or are you saying they can be charged under 45? Please tell us, because
I will tell. I have a simple answer to that.
Why we are telling you, the setting of 497 in the Indian Penal Code is of general application. Correct? Somebody who is not in an employment, somebody who is not with the armed forces, that is a different thing. They have a different regime, which is the Army Act, Article 33. So if you cannot then say that we are outside the embrace of the discipline which is sought to be enforced on us by statutory provisions, which are different, which separately provide in very wide words.
My lords, my lords,
We will clarify that now. Now that we are clearing our mind.
my lords, 490 does.
You thought of only saying that it will not apply. You have made us feel that we should clarify.
My lords, the judgment in Joseph Shine does not talk about the 3 statutes which have been in connection with which a clarification is sought before your lordships. There is nothing in the judgment which talks about either of the 3 acts or about a workplace. An example was given that even in civilian workplaces, there is a requirement of disclosure of relationships internal. That comes from a right place of law. That is to ensure that there are no allegations of sexual harassment or an attempt to make.
Gosh, we will ask you another question. Forget about state employment. Huh? You have private employment. Correct? In one of the items of misconduct, which is more carefully articulated, unlike the very loosely worded unbecoming conduct, is if a person commits adultery, action can be taken. Action is taken, and he is thrown out.
My lords, insofar as
what will happen? We're just asking you whether you can that employee say, sorry, even though actually I am doing adultery, 497 has been struck down. Your employer, you can't touch me. I will merely carry on with adultery, but sorry, your hands are tied. Can you say that?
My lords, let us look at Joseph Shine as a judgment first and see what are the consequences of Joseph Shine and what is the premise and the ratio of Joseph Shine. The Joseph Shine judgment strikes down 497 and consequently 198. In coming to that conclusion, it proceeds on 2 separate premises. One is manifest arbitrariness and therefore Article 40, where it looks at the construct of the section in question and finds that there is no rational nexus as to what the purpose it seeks to achieve and how the manner in which the so-called protectee of the section, that is the wife in question, is being treated under the section.
That's right.
The second construct, the premise was...
We'll just chip in with our understanding of Joseph Shine. Joseph Shine has not sort of say that it's a moral good.
It doesn't.
On the other hand, it says that it will continue to be a ground for divorce.
2 months.
So it is a ground for divorce. Joseph Shine proceeded on its understanding of Articles 14, 16, and 21. And the fact is, the husband of the wife alone can make a complaint, 198. Wife cannot make a complaint. So you brought in Article 14, discrimination. You went ahead and you shut it down. It is void because it's not a case of fundamental rights being violated. It is void. Apart from 497, we are telling you in the context of employment.
Well, I'm just coming to that. Because 14 is not the only premise on which it's struck down.
If it is so, then even for the ground for divorce, it should not be.
2 minutes.
Why not? Even a ground of divorce, it should not be.
The reason why it continues.
So good.
No, my lords. The reason why it continues to be a ground for divorce is that adultery is adverse to the marital relationship between a husband and wife.
Correct.
Is not questioned. That there is possibly a break in the relationship between the husband and wife and their continued relationship as a married unit.
Correct.
Is one of the grounds which a person who is impacted by the adultery of the other person can take for a ground of divorce is that I do not wish to continue living with you because you have entered into an extramarital affair and I am the party, who is the affected party, I do not wish to continue living with you.
Correct.
That is...
Therefore, it's something which goes to uphold the sanctity of marriage.
My lords.
It goes to it because the reasoning in Joseph Shine is that keeping it as a criminal offense does not, go to uphold the sanctity of marriage. If you're saying on the civil side in a divorce petition, it is necessary because if I lose faith in my wife and then say that because she is living in adultery, I will not have anything to do with it.
Yes, ma'am.
In the Hindu religion, in the Christian religion, it is treated as a sacrament. In the Mohammedan law, it is a contract.
Hindu marriage.
Correct. So there are different underpinnings of it, which
I do not deny. My lord, let's break it down.
We have seen murder cases which have originated from adultery. We have seen the kind of, the strife that it has brought in, the disharmony with all, we have witnessed it. As judges, we have seen what happens, particularly when, marriages are torn asunder by adultery. What happens with children? I can relate to you any number of incidents. So it is, we don't...
My lords, let me not be heard as saying that I am taking the action of adultery lightly, or I am making a submission lightly on the actions and consequences of adultery. I am candidly submitting that I am not addressing the emotional aspects of it. We therefore are looking at a circumstance where there is an application that has been filed, where two questions have been framed for my Lord's consideration, and a prayer has been made. Correct. The prayer is to permit them to prosecute a specific direction whereby they wish to incorporate by a dictum of this honorable court promiscuous and adulterous acts within the provisions of section 45. My lords may kindly see with me once the prayer.
Well, we were also about to request you to read the prayer. We are now half inclined to actually allow the prayer.
My lord would then allow me to
read the prayer.
Yes, ma'am. My lord would come to page 27.
Yes, we are right. That's in front of us.
The persons subject to Army Act, Navy Act and Air Force Act by virtue of Article 33 of the Constitution being a distinct class, any promiscuous or adulterous acts by such persons should be allowed to be governed by the provisions of section 45 or 63 of the Army Act, sections 45 and 65 of the Air Force Act, and section so and so.
So tell us what is wrong with the prayer.
My lords.
Tell us what is wrong with the prayer.
This is by way of a clarification to the Joseph Shine judgment, which judgment does not pertain to, nor does it discuss any of the statutes.
Exactly that.
Second, my lords, the provisions in the question provisions or the relevant provisions that we are talking about do not identify any specific conduct. They pertain to certain conduct which they believe are impermissible in terms of the code that the military follows. My lords, it has to be determined on a case-to-case basis whether a conduct by a person would pose against the military's ethos. There could be a circumstance where that a husband and wife are separated and deserted for 15 or 20 years. There are ongoing marital disputes and a complaint is made. Were my lords to incorporate specifically in these provisions that any promiscuous or adulterous acts would be read into these provisions without looking at the facts and circumstances of the case, my lords would allow a barrage of complaints to be filed. Simply because there are parties engaged in a marital dispute, allegations would be made, and because of the mandate of this court, even the military officers will not have an option to evaluate on a case basis, and they would be necessarily required to input this provisions.
If you're saying that, would you have an objection if we clarify that in the decision of this court in Joseph Shine will not stand in the way of their taking action under section 45 and 63 in cases where unbecoming, so-and-so's elements which are mentioned therein, including promiscuous and adulterous act, put it differently.
Would my lords require to clarify that?
Because the judgment is being cited by you.
My lords.
Not you means, whoever is.
My lords, nobody has cited a single judgment. There is not a single case that my lords would recall that on an earlier occasion, my lords had called upon the government to cite which are the cases where this issue has come. No affidavit has been filed to that effect, my lords. No case has been brought to my lords' notice where this issue has come up.
No, Ms. Ghosh, we can't be looking into how, in a given factual scenario, how the situation would play out in a disciplinary proceeding. Let's take it as a disciplinary proceeding, right? How the scenario would play out in a given factual scenario, that we are not required to contemplate here. We are all in agreement here that the judgment that we are talking about had nothing to do with these provisions of the Army, Navy, Air Force Act. To that extent, you agree. That's a factual thing. The court had no occasion to look into those. Now, how they would play out by application of the Army Act and the Navy Act and the Air Force Act provisions, we don't have to.
My lords, I am not quarreling on the first part. In fact, my lords, a statement as my lords were.
No, even Miss Diwan was agreeable to have just that bit of a declaration. That's all.
My lords, we are not contesting an order by this honorable court to the effect that there is no need for a clarification because the judgment in question did not deal with this provision.
That's all has to be. That's all has to be said. Then why we are doing all the arguments then?
This was only in the context that in cases where they seek to invoke, that should be.
So how they play out in a given scenario, I don't think that is something.
I bow down, my lords. My lords may consider stating to that effect. Should my lords seek to do so? That the judgment in Joseph Shine did not deal with any of these statutes, and consequently, whatever actions need to be taken will be as per the provisions of law.
That's what we told you, that you chipped in with a lot of objections to even that.
No, my lords, I was not objecting to that. I only wanted an additional clarification. Since my lords are not keen on it, I would respond.
Yeah. Who else is there?
Shall I just point out a few aspects?
That answers my plenary objection. The only objection we have.
Who won?
Both of us belong to a category of officers who be convicted under 45 and 63.
What are the charge against you?
The charge against us is sexual relations with other officers. In my case, both of us are officers.
Okay.
The accused before your lordships and the lady with whom he is accused of having.
Does the lady officer happen to have a husband?
Obviously she happens to have an husband.
The marriage is not yet dissolved.
In my case, what happens is 6 years of matrimonial disharmony.
Correct.
No complaint by anyone. Talks failed. She writes a letter to them saying that the army saying that he is indulging in extramarital affairs, pending all these divorce disputes, and I am out. So that's the apprehension my learned friend also pointed out. In 6 years, nothing has happened.
That's right.
I am serving my army. After 6 years, when the divorce talks breaks, and a letter is written, and that's how I am pulled into this. But I have no problem. In fact, we can't have an argument with the court when the court is giving a clarification that Joseph Shine did not deal with these sections. Anything more than that, my lords, becomes an advance ruling on the validity of 45 and 63, with all due respect. That is what they wanted. The tenor of the application was that's all. Anything more than that is an advance ruling on the validity of 45-63, which we may or not challenge once our orders of court-martials are confirmed. So, if your lordships is to clarify that no clarification is required in the fact, circumstances of the case, given that Joseph Shine did not deal with either.
Then who else is there? Alishan Raj.
I am, yes. But I am on a lighter note. But I am reminded where I read Franz Kafka, the novelist elsewhere, who accused lawyers of making 10,000 words over a single document and thereafter calling it as a brief. And this applies to arguments as well, as a brief. As a brief. But this applies to arguments as well. Anyway, I don't intend to face that charge at all, in making my submissions. I will be very brief. I am straight away coming to the point.
It's already charged me. That's another.
Yeah, that's the only problem.
No, I am not charging my learner friend. It's a general.
Raj, you say that you will be very short. Don't say I'll be very brief.
I will be brief. I will be literally brief. Yes.
Who are you representing?
I did not intend to. Ms. Madhavi was not in my mind at all. While I was making the submission, I was making a very broad general submission. She was very brief. She concluded before lunch. I don't accuse her at all, because she is the petitioner. I am on a better wicket, actually. But I would, now coming to the aspects.
Who's your client? Whom are you representing?
I represent Joseph Shine.
Oh, you are the original petitioner.
I am the original petitioner. That's why, my lord, I was in a rather showing a bit enthusiasm to defend the judgment. Now, my lord, I would
I was asking whether you are an army man.
I am not an army man. I am not an army man. But I may make it very clear that Joseph Shine may not be understood to have decided anything with respect to the army persons or defense person or any of these 6 provisions in the 3 defense enactments. Your lordships are absolutely right. But the Joseph Shine did not deal with it. The prayer also is in the present application. In the present application says, the prayer in the present application, as it has been read over several times, that the person subject to Army Act, Navy Act, Air Force Act by virtue of Article 33 of the Constitution of India being a distinct class, any promiscuous or adulterous acts by such persons should be allowed to be governed by the provisions of Section 45 or 63 of the Army Act, Section 45 or 65 of the Air Force Act, 54(2) or 74 of the Navy Act. But I may say that this was not dealt with. That's a correct statement on facts. Joseph Shine did not deal with any of these provisions. But I should fairly concede that. But the point is, the problem is, when they file a clarification of something which doesn't require a clarification, that is slightly problematic, and that will set a bad precedent. My counterpart is there, Radhamani, Advocate Radhamani is there, she will hand over this judgment. One recent judgment of this Honorable Court in clarification may kindly be noted. Would your Lordship kindly just see that, that's a judgment reported in Live Law 2021, because it is not reported in SCC or in any other journal. On clarification. Lordship got it, my lord?
No,
that judgment is Live Law 2021, Supreme Court 564. But this is specifically on the issue of clarification. First of all, the court says, but paragraphs 8 to 12 may be relevant. Paragraph 8 to 12 may be relevant.
Then Supertech.
In Supertech, a clarification petition was filed. And then, relying on Gurdeep Singh Uban, but an earlier judgment of this court said that you cannot file a clarification application when it resembles a review, at least in parts. Review may not be necessarily the review of the whole judgment, because as your lordships are aware of, going by the scheme of the Supreme Court rules, review is decided generally by circulation. It is generally by circulation, unless it is otherwise ordered by the bench. But that is the format of Order 40 Rule 3, as well as the Supreme Court rules. Lord may kindly see in paragraph 8 of this judgment in Supertech, we're quoting Justice Jagannath Rao, Gurdeep Singh Uban was extracted. We next come to applications described as applications for clarification. Lordship got it? Page 9 of that OP. Paragraph 8. Lordship got it?
Yeah.
Yes. In successive decisions, this court has held that filing of applications styled as miscellaneous applications or applications for clarification or modification in the guise of a review cannot be countenanced. In Gurdeep Singh Urban, Justice M. Jagannath Rao, speaking for a 2-judge bench of this court, observed, we next come to the applications described as applications for clarification, modification, or recall of judgments or orders finally passed. We may point out that under the relevant rule, 41 of the Supreme Court rules, sorry, it is 15 of the Supreme Court rules, Excel, 1966. A review application has first to go before the learned judges in circulation, and it will be for the court to consider whether the application is to be rejected without giving an oral hearing or whether notice is to be issued. Then Rule 3 was extracted. Rule 3, unless otherwise ordered by the court. An application for review shall be disposed of by circulation without any oral arguments, but the petitioner may supplement the petition by additional written arguments, etc., etc. Then we had another judgment. Paragraph 18 of that judgment also may kindly be taken note of, as extracted, page 10. We therefore agree with the learned Solicitor General that the court should not permit hearing of such an application for clarification, modification, or recall if application is in substance one for review. In that event, the court could either reject the application straight away without cost or permit withdrawal with leave to file a review application to be listed initially in chambers. This is the general settled principle which has been followed throughout by this honorable court, by different benches of this honorable court. Page 9 also tells the same thing, where another judgment, Ramchandra Singh, was extracted, which followed Gurdeep Singh Awad. And then paragraph common cause, also Sahira Sahibullah Sheikh versus State of Gujarat, telling the same thing. Paragraph 10 talks about another judgment, Rashid Khan Pathan. Then coming to 11 and 12, which is the latest pronouncement on this clarification application. Paragraph 11 may kindly be seen. This is the paragraph 11. The attempt in the present miscellaneous application is clearly to seek a substantive modification of the judgment of this court. Such an attempt is not permissible in a miscellaneous application. While Mr. Rastogi, Learned Senior Counsel, has relied upon the provisions of Order 15, Rule 6 of Supreme Court Rules 2013, what is contemplated herein is a saving of the inherent power of the court to make such orders as may be necessary for the ends of justice or prevent an abuse of the process of the court. Order 15, Rule 6 cannot be inverted to bypass the provisions for review in Order 27 of the Supreme Court Rules of 2013. The miscellaneous application is an abuse of the process. The hallmark of the next is important. The hallmark of judicial pronouncement.
We have seen it.
Yes. All that I am saying is, but I will just read this paragraph just for the purpose of conceptual clarity.
Just 1 minute, 1 minute, 1 minute.
After entertaining that.
Yes.
Please. So, by the principles laid down by this court.
Yes.
Absolutely. We agree on the principles.
Yes.
No discussion.
Yes.
But kindly see this particular order which you are citing to us.
That I understand. Yes.
What is the prayer?
Now see the prayer quoted in paragraph page 1, para A.
Yes.
The prayer was demolish part of tower number 17.
Yes, yes.
Okay. This is the prayer. They want a modification. Then that demolition will take place part of tower 17. Now turn to the page.
Correct.
The division bench at the High Court said demolition of tower 16 and 17.
Correct.
No part of 17. Okay.
Yes.
And come to this court's order, which has been referred to a para 185 in paragraph 2 itself, Roman 3.
Yes.
Demolition of tower 17.
Yes.
Nothing part without para 17, tower
Yes.
17.
Yes.
Now, this reference,
yes.
If the miscellaneous application is filed,
yes.
then look here, you might have considered tower 17 for demolition.
Yes.
The High Court has considered and deliberated for tower 17.
Yes.
This court also considered for demolition for tower 17, but now make a modification.
Absolutely.
And part of tower 17 will be demolished.
Absolutely.
That be permitted.
That's right.
The court said you can't file an application for miscellaneous application for
That's right.
clarification. Here we are dealing with a matter where there is no subject matter available before the court.
Correct. But it is usually said. I agree, my lord. I cannot disagree with when your lordship say this, because there are no precedents on facts, as it is generally said. Precedents are only on law. Only on law.
But in this very judgment, in para 4, it is observed. A constitutional court cannot remain enriched in a precedent, or the controversy relates to the lives of human beings. The very same judgment.
Correct.
Signed judgment in para 4.
I don't say for a moment, Shall I just clarify my position? I don't say for a moment that in no eventuality a clarification. Even recently, your lordships clarified, my lord, that in the living will case, in the passive euthanasia, your lordship did it, and that was required to be done. And the very many persons were rather rescued because of that clarification. The impediments were removed. I don't say, I may not be taken as saying that a clarification is always impermissible. That's not my argument. The argument, is rather reflected in paragraph 12 of that judgment. I will then come to my proposition. Paragraph 12 of that judgment, your lordship may please to see. The hallmark of judicial pronouncement is its stability and finality. Judicial verdicts are not like sand dunes, which are subject to the vagaries of wind and weather. A disturbing trend has emerged in this court of repeated applications, styled as miscellaneous applications, being filed after a final judgment has been pronounced. Such a practice has no legal foundation and must be firmly discouraged. It reduces litigation to a gambit. Miscellaneous applications are becoming a preferred course to those with resources to pursue strategies to avoid compliance with judicial decisions. A judicial pronouncement cannot be subject to modification once the judgment has been pronounced by filing a miscellaneous application. Filing of a miscellaneous application seeking modification or clarification of a judgment is not envisaged in law.
But in the context of the prayer in that application.
Yes, I understand. In every decision, my lord, that exactly, my lord, what I would say about Joseph Shine also. Joseph Shine, as your lordships rightly observed, did not pronounce upon a person's culpability.
Your appearance can be put to you because you're the person who is who was responsible for bringing about that judgment in the manner of speaking. If in a section 45 charge proceeding,
yes,
the ingredients are exactly that he committed adultery.
Yes.
Will the Joseph Shine judgment stand in the way of the army authority taking disciplinary action, which is essentially a disciplinary action because the result is going to be cashiering?
Yes.
It's going to be ending up in a jail.
Yes.
So, would there be any insuperable obstacle for the authority in doing that? Just we wanted to know what's your dilemma.
My answer is crystal clear. There is no impediment created by Joseph Shine in such a course of action. Your lordship can even refer to this as my submission. There is no difficulty in that. Because I want to be fair on that. The point which I am making is only this. But the problem is something which is not there in Joseph Shine. Now I will come to straight away to the point. Something which is not there in Joseph Shine or in any judgment for that matter. But people across the country will be citing the judgments of this honorable court to either distinguishing it or relying on it or saying that it is not applicable to the facts of the case, etc., etc.
Yeah.
But will that give rise to a cause of action for clarification of the judgment cited is the question. Precisely. But there will be hundreds of occasions where Joseph Shine is cited or distinguished or relied on. Because somebody cites Joseph Shine or distinguishes Joseph Shine or relies on Joseph Shine, rightly or wrongly, can that give rise to a clarification application is my respectful question which I ask myself.
You see, there is another thing.
Yes.
Why they perhaps came in. Perhaps what the condition is because they might have come here with this.
Yes.
They perhaps want a message from the highest court, and that will give strength.
Yes.
That what has been held in Joseph Shine.
Yes.
Not come to the rescue of members of the armed forces.
Correct.
If they were to, as you very correctly and fairly pointed out.
Yes.
If they were to be charged under section 45 or 63,
yes,
they can be proceeded when there is no obstacle.
Yes.
That is what prompted them to come in.
Absolutely.
And even, it is unlike, we are not modifying the judgment.
Yes.
Since the court did not deal with Joseph, with the Army Act, we are not modifying the judgment at all. We are only saying that was in the context of, and therefore it will not apply even to that extent we can go.
Correct. I perfectly understand what your lordships are thinking. I just perfectly understand, but it may not be taken, my lord, as I am opposing what is coming from your lordships. But I essentially agree with that. The point I am making is slightly, my lord, in a different context. The point which I am making is whether, my lord, a clarification, allowing a clarification as has been sought as a general proposition, what will be the impact of that clarification in individual cases is something which your lordship may kindly consider. I am only on that. Nobody.
Leave open all the contentions of the
That's what I'm saying. I will just put it in this way. Two judgments for illustrative purpose, not for precedential purpose. Two judgments which I have given to Advocate Radha today for illustrative purpose. Where, my lord, in army, in defense, one is an Indian judgment of dishonorable court 2019 13 SCC 723. I'm not citing this as a precedent, my lord, I may make that caveat. And the other is a US judgment, Paras versus City of Roseville. Two judgments. I will come to the first. This is a case where I will just clarify my argument. This is a case where an army officer was proceeded against for bad conduct. What is stated therein is disciplinary proceedings were initiated stealing affection of brother officer's wife. This just for illustration I am telling this.
That's right.
Pardon me, Lord.
So that's right. I mean, you have seen that. So that can be done.
That can be done. Then what I am saying is, in this case, but despite this allegation, this does not say specifically about any of these.
You have to prove the allegation. You have to prove the allegation.
Prove the allegation, and if it is not proved, even in departmental context, it's an illustrative case where allegation was raised something akin to adultery.
I mean, these are all basic assumptions. You have to prove that case.
That's what I'm saying. That's what I'm saying. So in an individual case, no,
we are not going into that area at all.
No, that's what I'm saying. Your lordships may not go to that area is my submission. That's what I'm saying.
We are making establishing the case. That's distinct from whether you can make out a case.
Yes, my lord.
Distinctions.
Correct. Yeah. The point which I am trying to place, my lord, in this case, the point is only this.
Only thing we are going to say that does not apply, is not intended to apply.
Very well.
Do it the way you are first.
Individual cases, this should not
although
apply.
my learned friends have perhaps been more persuasive than I have on this, so my lords would consider, because they have very fairly stated that 45 and 63, my lords, I can
We're
still
not in the contemplation of the.
But not only not in the contemplation.
No.
There's an application maintained.
Shall I just point out one aspect, one single aspect, which may be slightly relevant?
Okay.
This is the point. Just your lordship, Justice Joseph was pleased to ask Lord 3 pertinent questions, not citing 3 examples. 1, Lord, when there is consent. 2, Lord, when the act is involving intercourse. The point, that's why where I was trying to interfere, in the sense that I just wanted to make a point out of those questions. The point is this: it is not on account of the decriminalization of adultery in Josephshire that it happens. The autonomy of these 3 defense enactments and the 6 provisions which the ASG has been pointing out are independent of section 497 even before decriminalization in Josephshire. It is independent of it. Therefore, what I would submit is that tomorrow a private employer also can come here and say that my employee is not in a good conduct. So I expect that she may in future rely on Josephshire. So please give an anticipatory declaration. But that a constitutional court will not give is my submission. Like an anticipatory writ, An anticipatory declaration or order also is impermissible. Is my submission.
It's an application. By the Union of India, is it? Yes. Union of India. Seeking the following as clarification. Page 27 of the applications. Applicant is seeking clarification of the endorsement which is reported in 2019, volume 3, SCC, page 39. It must be noticed that the applicant was the sole respondent in the said case. Paragraph B. The reasons which have driven the applicant to seek the clarification are as follows. In the case of the applicant, that this court has undoubtedly proceeded to find Section 497 of the Indian Penal Code as unconstitutional as it offended Articles 14, 15 and 21 of the Constitution. However, it is the case of the applicant that officers of the armed forces are subject to statutory provisions, namely the Army Act, the Navy Act, and the Air Force Acts. Our attention is further drawn to Article 33 of the Constitution. It reads as follows, extract. It is the case of the applicant that an impression has been generated and is sought to be perpetuated. That in the light of the judgment of which verification is sought, nothing more would survive, even if a case is made otherwise under relevant provisions of, just say, hereinafter referred to as the Acts. Hereinafter, under the provisions of the Acts in question. Srimati Madhavi Diwan, learned additions officers, there two appears on behalf of the applicant, would address the following submissions before us. She drew our attention as an illustration to the provisions, the following provisions of the Army Act 1950. Chapter 6 deals with offences. Thereunder, our attention is drawn to Section 45, extract 45. From system further, she draw the attention to Section 63. Finally, you should draw our attention to Section 69. She would immediately point out that in the light of the judgment of this court, in so and so since Section 497 of the Penal Code has been struck down as unconstitutional, and it being a civil offence within the meaning of Section 69 of the Act, it may not be open to the authorities to proceed against an officer within the meaning of under Section 69. That's what you said. However, it's a further case that will not preclude the authorities from invoking the provision Section 45 and or Section 73 of the Act. 63. 63 of the Act. This is why we are detecting, if we go and preserve him, commit all kinds of mistakes. There are similar provisions also in the Navy Act and in the Air Force Act. It is not sufficient that the word adulterous acts would bear the meaning which is assigned to it in the dictionaries. So also the word promiscuous, and it need not be found integrally connected with Section 497 of the Penal Code as such. The members of the armed forces, according to her, class apart. She also drew our attention to the objects and reasons of the act. It is pointed out that the act was enacted, the law was enacted to provide for an exhaustive code. It is a complete code. It provides for self-regulation. According to her, the decision of this court in Joseph Shine must be viewed in the context of the institution of marriage. It was not rendered in the context of a workplace. Expanding further, the additional Solicitor General would point out the setting in which the armed forces operate constitute a unique workplace. Discipline among the members of the force is a matter which is indispensable. Discipline would indeed be eroded, according to her, if the high models now to be occupied by members, by the officers, is diluted. The obstacle in the authorities invoking Section 45 and 63 of the Act, with as also the corresponding provisions in the provisions in the corresponding Act, the corresponding provisions in the other two Acts, will ultimately result in a situation where, in a sensitive forces as the armed forces are, it would engender and breed gross indiscipline. The forces which are to always act as one and proceed on the existence of a sense of brotherhood would break down. This was not what it was in the contemplation of this court, and it grounds Section 497 of the Indian Penal Code unconstitutional. Section 497 has been struck down on the basis that it offended Articles 14, 16, and 21, 15 and 21. The court, it is contended was distressed by the resort to values of a bygone era, bracket the Victorian era. And the considerations which persuaded this court to hold Section 497 are not germane for the purpose of deciding on the validity and legality of actions taken under Sections 45 and 62 of the Act.
63.
63. She, in fact, did point out that there was an element of discord even in the matter of the right to privacy, which has been advocated in one of the judgments, in the judgment of one of the learned judges, whereas it has not been so canvassed in the judgment of another judge. There is a command structure in the armed forces which it is indispensable to maintain. Such command structure would be impaired and disturbed. She would, in this regard, ask us to focus our attention on the word what are that words? Inappropriate behavior. Unbecoming conduct in section 45. She would submit that in a case where the officer is charged with what is unbecoming conduct and which consists of an act of adultery. Nothing can stand in the way of the authorities taking action. Importantly, pertinently, she would also point out that the provisions are gender neutral. A voice which was, and it does not suffer from the vice of being not so, as found by this court when it struck down section 497 here. Or it may be man or woman who acts in a manner which is found to be unbecoming can be proceeded therefore under section 45 of the Act. Equally, she drew our attention to section 63, 63, and points out the importance of the words military discipline besides good order. In other words, any act or omission which is not specified in the Act is found to be prejudicial to good order and military discipline would invite action under section 63. She even went to the extent of pointing out that it can lead to a mutiny. And she would further submit that it has in fact happened. And taking it correct, there's
a very unrestful situation. There's a lot of
unrestful situation.
Breakdown of discipline.
Unrestful.
Yes, unrestful or a breakdown of discipline.
A breakdown has in fact occurred. She would therefore point out that in this court made, and she would further point out that the Union of India is faced with the following situation. Action is taken under section 45, Institute, section 3 of the Act. It is being challenged. The board of contention raised by the officer is that the action is tabooed by virtue of the judgment of this court. This has led to number of cases piling up. There is a certain amount of chaos. This doesn't conduce to discipline being maintained in the armed forces. But we've also had benefit. We also had benefit of hearing. So please take your name.
Ananya Ghosh.
And Parmeshwar. They are counsel who appear for intervention. It is pointed out that by them that the application for clarification may not be allowed to. You must say one more figure. Must be the one runner additions also to the service. that this court may at least declare that, we have at least clarified that the judgment of this court was not concerned with dealing with the provisions in question under the acts. So then you come back to this. They would sort of sense of motion that would submit that there is no case made out for ordering a clarification. The proceedings would have to be decided on the facts as are relevant to each case. The application for clarification may not be the solution to the problem which is projected by the applicant. In individual cases where this question may arise, it is for the applicant to work out its remedies, and this court may not issue a omnibus clarification sufficient. Strict correction and large paragraph. The Law Council appears for the petitioner, Joseph Friend, in the main judgment. He would submit that the application for clarification may not be entertained. In this regard, he drew our attention to an unreported judgment of this court and an order of this court. It's a reportable order, isn't it?
It is reported in live law, but not in this SCC. Live law 2021 Supreme Court 564. Yes, the citation.
We may at once notice that the applicant was filed seeking the following prayers at page 241. No doubt this court has proceeded to go into the question as to the maintainability of the application. In principle, the court has adverted to the following judgment by this court in Gurdeep Singh in the state of the matter 8 alone. This view apparently has found acceptance in subsequent judgments. It was found undoubtedly in the facts of this case, the said case, that the attempt was to barely seek a substantial modification of the judgment. Thereafter, undoubtedly, this court also held that as follows the first few lines of paragraph number 12. He would submit that there is no occasion for the applicant to file the present application. The Law Council for the petitioner in the main case would, in fact, agree with the applicant that the questions which have been raised in the application seeking clarification were not the matters which arose for consideration in the main judgment. This court was concerned with the validity of section 497. He pronounced on the same. It had nothing to do with the provisions of under the acts. He would submit that no occasion as ever said from the court to clarify the orders accordingly. In fact, when this court posed the question as to whether, if in a given case, the authority is presented with the following set of facts. An officer is proceeded under section 45 of the Act. The charge against him is adultery. It is alleged, in other words, that he has committed adultery within the meaning of section 497 of the Indian Penal Code, which has been struck down. So, Kalishan Judge, Law Council for the petitioner, very fairly submitted that the fact that section 497 of the Indian Penal Code has been struck down may not stand in the way of the authorities proceeding against the officer with the aid of the provisions contained in section 45 of the Act. Correct? That's why we are dictating it.
Lakshmi also add that every individual case should be, according to my humble submission, will have to be considered on the facts of the respective case. That will not take time.
We'll say that. We'll say that.
Yes.
Of course, he adds that the decision must finally depend upon the play of facts and for play of facts. Full stop. Paragraph. The judgment of this court, so interesting, was concerned only with the validity of Section 497 and of the Indian Penal Code and Section 198 of the Code of Criminal Procedure.
You may specifically say, Section 198(2) of CRPC. Only subsection 2 will apply. Other sections are irrelevant.
But in fact, the Remand judgment, the whole of 198 has been struck down.
That was not
struck down only because
in so far as it applies to 497, in that way it is struck down. 198(2) will apply in certain other contingencies. Court is not audible.
in separate opinions. Over there were agreed that Section 497 of the Indian Penal Code and Section 198 of the Code of Criminal Procedure were unconstitutional. The reason given was, and in the ground on which this provision was struck down was they offended Article 14, 15, and 21 of the Constitution. In this case, this court had no occasion whatsoever to consider the effect of the provisions of the Armed Forces Act, I mean the acts in question. In fact, we may notice that it is not as if this court approved of adultery. This court has found that adultery may be a moral wrong.
Yes.
This court has also held that it will continue to be a ground for securing resolution of marriage. I mean, please correct that is why we are debating resolution of marriage.
There's only one judgment on that. The others, there's
yes, you can give who said it.
Justice
Malhotra.
So permission is saying it's not right. Very good. Yes.
I am only going with what the judgment.
You are right. You are right. Give the name.
Justice Malhotra's judgment.
Justice Malhotra, but Justice Deepak Mishra also said that it is a kind of civil wrong. It can be a ground for civil.
It will also be described as a civil wrong.
Yes.
In view of the fact that the scheme of the acts in the context in particular of Article 33 of the Constitution did not fall for the consideration of this court. We are of the clear view that we must observe and clarify that the judgment of this court was not at all concerned with the effect and operation of the relevant provisions in the acts which have been placed before us by the applicants. In other words, this court was neither called upon nor has it ventured to pronounce on the effect of Sections 42 and 63 of the Act as also the corresponding provisions in the other acts.
45.
Provisions of the Act, any other provisions of the Acts. We only make this position clear and dispose of the application.
Yes. Well, just one small thing, wherever your lordships have said officers, in the context of 63, personnel are also covered. Non-officers are also covered.
Officers, spokesperson, entities.
Yes. And my lord, the incident which, my lord, I related to, about the unrest was, my lord, maybe not strictly adultery, but it was inappropriate sexual behavior. So, my lord, I'm just clarifying.
That's right. You can register following an inappropriate, in fact, following an inappropriate sexual behavior, what situation of unrest followed.
I'm grateful.
Why do you use so much negative words? Unbecoming,
applications and the improvement applications are
straightforward.
Including an intervention applications are allowed.
Yes.
We have to allow it to the beginning, only that we can hear that.
So, the second miscellaneous application has improvement and permission. The second MA also is have an improvement application in it, and then.
What is the second MA? Madhavi, before you go.
Yes, I'm appearing that one. Second MA. Same. One is numbered as an IA, the other one be numbered as an MA. Intervention and permission to.
Improvement, your lordship?
It's substantially the same.
It's substantially the same.
No, exactly. Are there two applications of clarification?
Two MAs are there. One.
Because the second MA is filed by my client. It's
your client is filing.
Yeah, it's not for clarification. It only says the MA for intervention is numbered as an MA instead of an IA.
Oh.
The application for intervention is numbered as an MA. That's all.
So that is all.
I'm extremely grateful for.
My lord said indicated your lordship to keep all conditions open.
We're closing.
My lord said
in the on.
Since we have not gone ahead and given a direction, we have only said, why should we keep intervention open?
Yes, my lord.
Because this would also, so you don't want this to be used as a imprimatur of the constitutional.
This is not their competence.
Parameshwar, there are only 3 concurring because concurred with that main judgment. 2 judges, main judgment, 3 concur.
Oh, that's it.
So you said 4 concurring judgments. Then there should be 6 members in that.
Why you are asking for this contention?
Like they gave an apprehension. Now our apprehension is that this becomes a imprimatur on the validity of those acts. That's all. On those provisions.
Nothing apprehension. It is not.
That may have to be decided in a separately constituted.
We have not decided anything. We have said that the court is not doing anything.
That can be clarified.
Obliged.
Nothing more is there to be clarified. When we have said that and disposed of it.
Very obliged.
We are grateful.
Yeah.
I'm extremely grateful your lordship permitted me to be online, but it's only due to some constraints, not otherwise.
We are also thankful.
Accessible. Have to make the boss is
Yeah.
So far as this matter is concerned,
Yeah, now you must make your.
now we can make our request.
I do.
Yes.
Please report first.
Yeah.
No, but that's
Now tell us how many cases are there?
well, it's actually this litigation is directed towards WhatsApp, but the bill deals with Millard's intermediaries throughout the system. So, Millard, it's not a WhatsApp-centric litigation.
You got a copy of the bill, actually?
I've got Millard, yes. In fact, I have formulated something for your lordships to consider. We just hand it over to your lordship.
Only Millard, one. What we would have to see perhaps is.
Yes.
is the ambit of the bill.
Yes.
Versus the scope.
In fact, we have made that table.
Only a minute. One request I would earnestly make. The bill is to be introduced in the House. Please do not permit anyone to discuss the bill. It is the House which would discuss the bill. We can't discuss it here.
So if you say that, equally, they may say that we are in the limbo and we will not make progress in this way. Only time because
Yes, we made a table.
That's for your lordships to decide. I am only, my apprehension was.
It is not even in an embryo stage.
That's entirely your lordship's call, my lord. The only thing was that since it is coming in the second half of this session, it can wait for a few weeks more. That's all. But I can't, my lord, if he is. I'm supporting Mr. Diwan. I'm finding it really difficult to support him.
Mr. Mehta, you had filed an application. You had filed an application.
Yes.
I have filed an affidavit, my lord, pointing out this fact that subject to. Right, I just
the copy, the affidavit is here.
Yes.
It says that a bill was circulated for public comment. Comments have
let me read the
being collated.
I'm sorry, my lord. I kindly allow him, my lord. Kindly allow me to help you, please, sir. My lord, this is what I have said, my lord. I further state and submit that with a view to lay down a comprehensive legal framework governing digital personal data protection in India, MeitY, that is not the Ministry of Information Technology, etc., has formulated a draft bill. MeitY initiative.
Not having your application.
Not been given it over. It's filed. It's filed.
We have just filed.
Yes, copies are given. So we can give additional.
File कहाँ हुआ है? File मंगा लेते हैं.
Even if it is placed, can we make any observation touching that? It is a prerogative of the parliament.
It would be, my lord. It would be. We can't, at least, we can't, my lord, on this side discuss on that. Debate has to take place
there, not here.
Parliament. MeitY has formulated a draft bill title so and so. MeitY initiated a stakeholder consultation exercise on the draft bill, inviting comments from the public on 18/11/22, the last date for receipt of which was 2/1/23. MeitY is in the process of collating and analyzing the feedback and suggestions received with a view to take the draft bill forward. I further state and submit that as is evident from the above steps taken by so and so, subject to fulfillment of procedural requirements, intends to introduce the aforesaid bill in Parliament at the earliest. This was as on 11 January. Yesterday I received instructions that subject to fulfillment of again adverse administrative requirements, it has to be routed through cabinet, etc. Subject to that, we intend to introduce in the second half of this session. The second half starts from 13. So as to perennially keep the matter pending. That's all.
Well, it's quite a part.
Mr. Solicitor,
yes.
See, bill is yet to be introduced in Parliament.
Yes. Lord, I'll just tell your Lordship, Lord, second part of the budget session is from 13th March to 6th of April.
So is there any harm in our hearing the matter?
Lord, there is no harm. Lord. Your
Well,
Lordship can always.
I would like to respond to that.
There is no harm. Lord. My answer is straight. There is no harm. But if the petitioner's concerns are not taken care of by the bill, by the act, my lord, if it matures into an act, then, my lord, to a large extent, some extent, my lord.
The problem which we possibly can anticipate is in the event we decide the matter in one way and
the bill, my lord, actually deals with.
Yes, my lord. Then, my lord, it would be a second round of litigation.
that is a speculative measure.
Lord, in fact, your lordships, my lord, our assistance would also be by and large academic and speculative.
It's anticipated collision, not a.
No. I'm
Yes,
sorry.
that's
No, I'm saying, my lord, our submissions would also be more speculative than, my lord, having any legal framework before your lordship. Anyway, my lord, if it can't wait for 3 weeks, it can't wait.
Well, I can only say this to your lordship, this issue was dealt with in Puchaswamy. 9 judges of this court. Well, then I show your lordship the paragraphs on that where
So if this has already been decided on that basis.
No, not decided. That Manoj commented upon that as far as non-state actors are concerned, it is better that the bill, Manoj, is formulated by Parliament before the court deals with it. That's what Puttaswamy says.
24th August.
If you please allow me, sir, there's no point of intervening. I'm just pointing out what 9 judges have said.
No, now there is a constitution bench decision delivered last week or 2 weeks back, in which 19 and 21 it has been held, that is enforceable against non-state actors.
No, true. No doubt, Manoj. Nobody is disputing that. But what 9 judges says, this is such a complex area. And it has such complexities that court is not in a position to deal with these complexities unless the bill is before you. That's what 9 judges say. I'm not saying that, Manoj. So I just wanted to point out to your lordship. See, Manoj, paragraph 304 of Puttaswamy.
So by the time the judgment comes, my lord, the apprehension is, would, my lord, we be justified in preempting the debate which is to take place in Parliament?
Not only that, Manoj,
That's a
much of
matter
what your lordship,
not that your lordship cannot.
much of your lordship would be doing would be an academic exercise because the bill is overtaken, Manoj. This is the problem.
What is the clash?
The clash is, Manoj, every aspect of their...
We cannot look at the bill itself.
No, please look. I don't mind, Manoj.
No, my lord. I think, my lord, you are not
Part of the legislative process.
So it's not introduced yet. So there's just a bill which was circulated to the public for comment. That's very different from what will eventually, if at all, introduced in Parliament, which the Solicitor General applies the court.
It becomes property of the Parliament after introduction.
In any case,
Lord, if we are being that technical, my lord, your lordships can even set it aside. That don't introduce.
No. We want to see
The subject, I've seen it, the subject matter of the bill is exactly the claims that they have made.
Anyway, we would like to open tomorrow.
And we just
I'm only
as to what like to open. I have a
preliminary. We have not made our mind with
I know, my lord, your lordship,
whether to hear the matter.
That's right. So we'll make our submissions tomorrow on this. We'll make our submissions on this.
Address your lordships tomorrow.
I'll address your lordships tomorrow on this.
What the lead sought for.
Yes, Manoj,
see what take the
case. So I'll just indicate broadly as to where we are.
How many cases are there?
There are 4 shown on the call in the cause list. There's 502, 502.1, 0.2, and 502.3.
What are the petition numbers?
Yes. Now 502, which is the case where I appear for the petitioner, is an SLP Civil 804 of 2017. That, as I indicated, is what arose from the judgment of the division bench of the Delhi High Court.
Okay.
Then there is 502.1 shown as connected.
So that is from a 226 petition.
It is from a 226 petition. It's a petition which, in one sentence, challenges a specific change in policy which occurred in the year 2016. That was subject matter of the challenge. That it continues to be the subject matter. And we'll indicate.
Is it a live issue today?
It's an absolutely live issue today. It's a live issue today. There are subsequent developments to the 2016 policy, which we will also be placing before the court.
In a minute, what is your complaint actually?
Yes, the complaint in a minute, if I have to say that, in a minute, the petitioners before the High Court and now the petitioners before your lordships were WhatsApp users. They're citizens of India. And they had subscribed for this internet-based messaging service, which your lordships are probably familiar with, on a basis and a representation of what the extent or what the then privacy policy is or was. That policy underwent a dramatic change. And the change which occurred included, amongst other things, that WhatsApp would share certain elements of data, both personal data as well as metadata, with what I will broadly describe as the Facebook group of companies. So Facebook at some point had purchased WhatsApp, and they now said that they would utilize or pass on this data also insofar as Facebook is concerned. That was the subject matter of challenge as to whether this invades privacy rights broadly in a very, very general sense. What the High Court came to the conclusion was that, look, As far as privacy rights are concerned, that matter, as your lordships correctly observed, was still at that time pending before this honourable court, because it's a 2016 impugned judgment. Your lordship's judgment sitting in a panel of 9 is 24th August 2017, which is the judgment Mr. Sibal referred to, which said, please consider bringing in a data protection law. So that's more than 5 years ago. Anyway, keep that aside. So then the High Court held that, look, privacy, we are not going into it because it's a little uncertain. They cast doubt, which I should indicate to the court, with regards to the maintainability of the petition, qua private parties, etc. Then proceeded to give an exit. And they said that, look, within 2 days or 3 days, if you wish to exit user of WhatsApp, then you may do so. And in cases such as that, as far as WhatsApp is concerned, they will not share the data, they will destroy the data. Those details I will get into. The WhatsApp and Facebook have accepted the judgment of the High Court. They haven't come up over here challenging that particular judgment. In the meanwhile, when this matter came up here before the court, the bench presided over by Chief Justice felt that this was an issue which deserved to be decided by a constitution bench, and therefore it fixed the matter and constituted a constitution bench. The matter has been heard on occasions as recorded by this court's order in the past. Last it came up effectively in the month of September last year when a similar request was made. At that time it was hoped that the new bill would be introduced in the session which was around Diwali, etc. And everyone was hopeful that that would happen. As it came to pass, that did not happen. The original bill which was introduced. So after 2017, a bill was introduced for, generally I'll describe it as data protection. That bill came to be withdrawn by government itself. There's a further public consultation process. I might also add that the earlier bill which was passed and which was eventually withdrawn was also referred to a committee. So that's also something your lordship will keep in mind, because it's not as if the moment a bill gets introduced, the parliament, as the court correctly observes, has its own processes, etc. So my challenge is essentially directed at this action which took place in 2016 by a radical change in policy, and that policy itself has evolved. The limbs of my challenge are many. I first say, and it's going to be our submission, that insofar as the law laid down by this court in Puttaswamy is concerned, this would violate those particular foundational principles. Now, whether those foundational principles and the extent to which they finally become law and how they are applied, etc., is Parliament's prerogative. We are not going to go into that at all. So that's one limb of the argument. The second important limb of our argument is that WhatsApp operates across several jurisdictions. When it operates across several jurisdictions,
Europe versus America.
Yeah, it appears to have a certain differential standard when it comes to an individual user's privacy.
Which should
so,
not be.
For example, you cannot have a situation. You cannot have a situation where, yes, I'm sorry.
Two questions.
Yes.
One, you have the SLP against the Central High Court.
That's right, which is now before you. That's one. That's my case.
That's right.
The others will tell you.
What did the High Court do?
Yes, so what the High Court, as I told your lordships, was that it rejected the challenge. However, it gave an exit. The exit option which was given to users was that if on or before a particular day you stop using WhatsApp, etc., then your data will be deleted, it will not be shared, etc., etc. So there were certain directions which were given on that side. Which
take it or leave it.
Right.
Now, today we are allowing your SLP.
Correct.
That we are allowing the SLP.
Correct.
So forget about the bidding.
Right.
So what are the reliefs that we can get?
Yes, so there are declaratory reliefs which we are seeking. The declaratory reliefs are, and I'm again broadly indicating to the court what those are. So simply because I have already articulated this point, that you cannot share my data with the Facebook group of companies. So we seek a declaration to that effect, or at any rate, at a minimum, an opt-out option. Because what you will find when we explain the case, several users in other jurisdictions are given a meaningful option. When I say meaningful and informed option means that there are clear instructions. And if those instructions are followed, a person has an option to say, sorry, I want to opt out insofar as this type of sharing arrangement is concerned, or not sharing arrangement, which is not available to users in India. it ought not to be, if we are correct, eventually to persuade the court. Sorry.
It wasn't tried as a public interest.
No, it's an individual, it's a user. So there is obviously a public interest angle to this. There is a public interest element to this, but it's also by an individual user who says, sorry.
The declaration which you might persuade us to grant,
yes,
if that is going to be the subject matter of legislation, if Parliament is finally going to come out with a law which gives you the same relief.
No, it's not, Manoj. We don't know what if the law is not that. The bill which we have seen, I don't want to presume that I have any sense of the thing, except looking at the broad features of what we see. Mine is a very specific case to this WhatsApp. Sorry.
Connection between the bill spoken about and the need sought by you.
It won't have, there won't be an overlap.
That is what we are trying to find out.
No, there won't be. In my understanding, at least as far as my first item 502 is concerned.
It's a complete overlap.
As far as 502 is concerned, which is my petition, in my respectful submission, the bill will obviously, I mean, not the bill, I should say, if there is a law which comes to be passed, so it's very difficult for us to speculate as to what the parameters and what the exact contours of that law and act are going to be. However, insofar as my challenge qua the 2016 change in policy is concerned and the evolution of that policy, bringing it up to date, which we will do, is according to us completely impermissible under Indian law. And your lordships have also, in a previous order, used the expression which was counsel appearing for us, Mr. Salve was appearing for us, and he said that this change in policy is absolutely unconscionable. That's how your lordships have recorded his submissions, etc. So we will have to explain these parameters. This is not something which ought to be wished away. I'm sorry.
How long will you take, for example?
In terms of time? I think I will endeavor to complete tomorrow, but I may take one more half that session. If I'm given a full 2 sessions and maybe one more session spill over the day after.
I mean, I appear for a party called the Internet Freedom Federation. We were allowed to intervene in the matter. We were heard. When the matter was heard in 2017, we got by a constitutional bench of your lordships. Now, in response to what my lord asked about the relief, now this area is completely unregulated. They have been telling us from 2018 in Putaswamy, in the Aldar, it is forthcoming. Thereafter, nothing has happened for 4.5 years. So internationally, there are well-recognized privacy
regulated,
which any Milord and data collector has to follow.
Now, is there any international covenant?
There are Milord pronouncements. Pronouncement by the European Human Rights Court.
No,
that is confined to Europe.
There's no covenant.
Is there any UN treaty or something like that?
No, my lord.
If your lordship is asking us specific to this conduct, at least as far as we are concerned, we don't know. But there are general covenants to which India is a party, which we've adopted, which will be applicable. But let my learned friend.
The point is, the law, constitution, according to us, recognizes positive obligations on the state to enact. It can't be left unregulated. So when the state doesn't step in, you're not
regulated.
Step in, evolved without a mechanism and safeguard. When it came to telephone tapping initially, when it came to the prevention of sexual harassment inquiries, those positive obligations we seek, that your lordship by judgment recognize it and not leave it to the state, because last time
we have stepped in. My learned friend may not be aware. We have stepped in apart from this proposed enactment. We have stepped in.
Well, there are rules of 2011 which regulate
existing regime.
I don't know whether what my
It's not a Vishaka-like situation.
I don't know.
It's not a Vishaka-like situation. There is a provision in the Act. There are regulations which govern the position.
They don't give any more the opt-out option. Which
No, that you may have an individual belief, but
They will justify it according to those present regulations. Why are we waiting for an act?
See, can we rule out the possibility of minimizing the scope of this litigation once the bill is introduced?
Absolutely.
No. Suppose if there is such a litigation, why should we undertake an academic.
It's not an academic.
Today there's no bill.
Then it will be see after that what exactly is the point which is to be concentrated,
Correct.
which is to be considered.
Yes.
That the court can very well. Then the picture will be very clear.
My issues and you're not.
We will demonstrate the overlaps.
Examining this question.
Yes.
Public domain. It's not only the public domain.
May I make a suggestion? Manoj, the bill will be introduced in the second half of the session.
What is second half?
Manoj, in March.
13.
March till April.
Hold on. Just let me make a suggestion. Now, then you will know, Manoj, the bill will be before you. Then you will know if the areas are overlapping or not, and then you can decide. If the matter is to go on, it will go on. But at least have the bill with you.
For one moment, and
The bill will be introduced.
Yes, no. It's 502.2. I am taking the same challenges to the policy.
Who are you?
I'm a Indian startup, a society of Indian startups that has got a PIL under Article 32. I have a threshold issue which connects with all these issues and which no bill can cover, which is that if there are any challenges to privacy policies between private companies and individuals, then your lordships will have to consider what are the standards of judicial reviewability of legislations. Now, Justice Bose has said that a 5-judge bench has decided that 19 and 21 apply. Now, I have filed issues before your lordship. Your lordship will just take them up for a moment. But the issues are generally the 5-judge bench that has laid down 19 and 21 applies has laid down no tests.
The question is whether we take it today or
Yes, or tomorrow.
My threshold issue is
Let the legislation be before you, Manoj.
my position there. No bill is ever going to
Let
be
the
able to-
legislation be before you.
Lordships have to decide your
Then you will know.
But
May I suggest we assemble tomorrow
One second, hold on.
and take a call after hearing?
my position clear. Let me make my position
Not
clear.
for this purpose that whether you have to hear or not to hear. Our only request is one thing. If the matter is pending in this court for sufficient time,
I have a meeting.
and if we have been informed about that they may place the bill in the second half, what happens are not going to fall. We can
For 2 months.
Yes.
sometime.
If adjustment is being sought, granted, but ordinarily in a situation when the constitution bench says
No, that's
we have
right.
waited for this time, the matter is absolutely right for hearing. It is not academic. This is in anticipation that a bill may be introduced.
Will be introduced.
Passed.
What is that anticipation? It is clear.
It is clear that
Assuming a bill is tabled, it's not going to be looked at over here. The jurisdiction of the largest measures of WhatsApp.
Manoj, may I say this?
Tomorrow, you consider whether we should hear it because it's not going to be marathon hearing.
Yes. No, can I make my position clear?
No, we are.
Only a minute. Not so that your lordships can also.
Not that. He has to raise.
Only a minute more, Manoj. Only a minute.
Tell Roy.
Only a minute more. Only a minute more.
You don't know what prompts the judge to raise it for. You can't be.
No, not even a minute, Manoj. I'll not waste even a minute. No, I'm saying.
There are dangers involved.
He said I'm not wasting a minute, your lordship.
I'm committed to go and attend another meeting in the court premises itself.
then let
but
me-
that half a minute you please take.
Yes, okay. Not Mr. Diwan, even not so far as them and WhatsApp is concerned, I'm supporting him. There has to be a yes, Mr. Diwan has given an impression that he's fighting with everyone, but I am supporting him. So there is no not question of running away. But if any of the parties rely upon the bill and start debating here, that should not be permitted. That's all.
We're not doing it. We don't plan.
Well, it's already up for public discussion. It is for public discussion.
And we would be preempting.
See, if it is something which we can go through.
Yes, it's for public discussion already.
Public domain today.
I'll give you.
But there, comments are invited.
In a better position.
Yes, yes.
Comments are invited.
You have given.
Public opinion, but makes an observation, it will be having different. If the court makes an observation.
No, not observation, to find out the subject matter.
Find out.
Find out the subject matter.
The Lordship may not make a comment, but at least to find out
Yes.
whether there is an overlap.
Yes.
Since it is in public domain.
Then saying no.
Lord, he's saying no. If your lordships are to hear and then make a comment on it in the judgment.
Both sides, I am unable to cope up with the lung power on both sides.
We are not just saying.
Next to my affidavit. I'm not saying my bill is next to my affidavit.
The bill is attached to his affidavit.
Have a look at it.
Yeah, so we can
have a look at it.
You don't debate it over here. That's all I'm saying.
It's all a debate is all.
Send an affidavit. Yeah. Send an affidavit.